Thank you for that. If questioner number 1 and any other questioners succeeding questioner number 1 want to add anything, just mention questioner number 1 or mention number 1 and your additional comment. It gets a bit messy on the Facebook Live page. Okay, the question is as follows, and you can all see it on your screen. I applied for maintenance against the father, and I suspect he has taken retrenchment after we served him the papers. I can't claim for future maintenance. What can I do? It's a challenging answer because do you want me to be creative here and take the presumption that he will not pay child maintenance and we need to now attach his pension fund, his pension payout? Or if you have a concern that he will not pay, then it could possibly mean that you'd like to get a lump sum held somewhere. But that hasn't been confirmed yet. And the court did not decide on what amount of maintenance is reasonable. Is your claim reasonable? Should you be claiming more? Should you be claiming less? What can you afford? You might have obtained a retrenchment payout or will be receiving a retrenchment payout. What is that amount? Is it a huge amount of money? Is it required for his specific living needs? He worked for that, and he paid money every month into a retrenchment or retirement fund. I'm just being general here. And now it needs to be paid out, and he needs to use that money to look after himself. If he complies with his maintenance obligations and he pays whatever needs to be paid, then he can do whatever he wants to do with that money. It's his money. And that's my policy always, that as long as you pay your child support, your reasonable child support, what the children requires and what you can afford and in terms of your means and so on, considering all factors, the other parties, the primary caregiver's income expenditure as well, you can live the most lavish life you want to because you have complied with your obligations. I would presume the same applies to tax. If you paid your tax, you can do whatever you want to do with the balance of your money. The same with child maintenance. Pay it and that's fine. So in answering your question, the court first needs to determine whether or not there's a claim for there's a competent claim for child maintenance, in the sense of, is the amount that you're requiring or you're claiming from the other party, is it a reasonable amount of money, and is it an amount allowed in law? When I say an amount allowed in law, I mean based upon your income, your expenditure, the father's income and his expenditure, his future income. He might be cashing in on a retrenchment package, but at the same time, he might be working elsewhere as well. Or furthermore, he might have other assets. So the long and short of it is, please finalize the maintenance matter as soon as possible. Speak to the maintenance court about the retrenchment package. Mention that he is obtaining it. Maybe the maintenance court can obtain relevant information regarding that. So you have relevant data regarding the specific retrenchment payout. And after you obtain all that information and the maintenance order has been made, and he does not pay maintenance, then you can start looking around and say, no, we now want to start attaching the specific money that he has in his bank account, wherever it is. But I think your claim might be a bit premature now because you made a maintenance claim against the father. He is not in violation of any order, and there's no reason to believe that he will not be paying maintenance in the future. If he does do that, he's committing a criminal offense, and then you can proceed with a different claim, either garnish your order, attachment of an amount of money, whatever the case may be. So then you'll be in a better position to deal with that. I hope I answered the question. You are questioner number 1. You are welcome to pose any additional questions upon that. I have question number 2. Let me copy and paste that into the screen. As I mentioned earlier on, if you have any, if you're watching this video, please feel free to say where you're from, where you're watching this video from. It's always nice to know that. So this will be mark numbered. 2, and I'll delete the spot. I call this a whiteboard. I don't know if that's an appropriate term to use. Let's deal with this. Which act explains exactly how subpoena has to be served on a person? Please can you state the act? It's but difficult because then you will have the the regulations, civil procedure that would apply, the Magistrates Court Act, the Magistrates Court's rules. Then if it's a High Court, the High Court Act, the High Court rules. And then if it's in terms of maybe the maintenance laws, and the Maintenance Act might have certain regulations applicable or not. So it depends on those things, but I think that will be a bit premature for me to discuss that. The best I would say is determine that you want to obtain a subpoena. You approach the relevant court and advise the court you want to obtain a subpoena, and the court should be able to assist you with obtaining a subpoena for whatever reasons is required. The court issues a subpoena in any event. If it's a Magistrates Court matter, look at the Magistrates Court Act and the rules of the Magistrates Court. I would advise you to do that. If it's a High Court matter, look at the High Court rules and the Supreme Court Act, if I'm correct. Let's move on. An additional question 2. I'll just do this. What are the specific processes that has to be followed? Can I collect a subpoena from the court, take it to the police station, and ask the police officers to serve the accused? So an accused is a criminal matter. So you don't subpoena a criminal, an alleged criminal. That person gets, if the person must be subpoenaed, it will be subpoenaed by the police officer, by the criminal process. So I do not understand. Are we referring it to a maintenance matter? Possibly. I do not know. Or am I allowed to do this? Is there a specific process as a commander of the police station was trying to convince me there is another way? Only the court can send it to the police station. I disagree, as I have personal experience of this. Thank you. I do not feel this falls under the category of child custody and child maintenance, and it's a procedural aspect. The best thing I would advise you to do is have a look at the law, speak to an attorney, say you want to obtain his services. Can he serve the specific subpoena on other party? I do not know what type of subpoena it is. It is for non-compliance with maintenance order, is a maintenance application subpoena, criminal, civil. So those are all different specific scenarios that would apply. I hope you good luck with the specific issue you have, but it doesn't really fall under the topic of today's discussion, being child maintenance and child custody issues, not necessarily civil procedure or criminal procedure, and how to bring someone to court. That would be the court's job, or alternatively an attorney, but it's a different topic. I hope that assists you, and I'm sorry I could not be of any additional assistance regarding that. Okay, I think we have question number 3. Let us copy that one quickly. Question number 2, if you have any additional comments that you're welcome to mention it, and I'll paste it and I'll answer it. My answer might be the same, it might be different, depending upon the facts. Question number 3 also following: what does it cost to get equal custody and time with my son? I would presume you're referring to financial cost in legal fees. It can be free, because if you approach the children's court, you can represent yourself. It can be further free if you approach the High Court. You represent yourself. There will be no cost applicable. If you want to appoint a legal representative, I cannot thumbsuck here how much it will cost. It will depend on various factors: the lawyer's hourly rate, how much time he has to spend on your case, time drafting, court appearances, and so on. Is the matter opposed? If the matter is opposed, meaning the other side wants to fight against you, then the cost can be for anything from here till there. How much petrol does a party want to throw into the car? So for every strike the other party makes, you need to defend and counterpunch, for lack of a better way of stating it. So I cannot say how much it will cost, but I do know some matters are done very speedily. Unopposed matters are quite simpler than opposed matters. Unopposed meaning the other party is not opposing the relief sought, and the court will also have to determine the case based upon what you are saying and what's best for the child based upon what you are saying. I do not want to guess. High Court, Magistrates Court, I do not want to put any figures out there. It will just be a guess, and the guy sitting next to me can be non-lawyer. His guess will be just as good as my guess. But if the matter is unopposed, it will be reasonable. You can fix the amount more or less. It's an application either in the High Court or the Magistrates Court. If the matter is opposed, the fees can just spiral. Postponement after postponement possible, or it can be done very simplistically, depending upon the court, depending upon the judge, depending upon the facts. I hope that answers question number 3. I see question number 2 posed another question or comment, sorry. Because for the sake of fairness for everyone, I would like to do justice to all my questioners. I do not want you to think that I don't deal with you. Yes, it's a maintenance matter. So I presume it's a criminal complaint for non-compliance with the maintenance order. It's not your job to serve the subpoena, and I don't think you should. You can serve the subpoena. A police officer should serve the subpoena under these circumstances. I honestly do not believe that you can do that under these circumstances. It sounds like a criminal matter referring to an accused, and it's not the complainant's job to serve it. And the final comment would be no problem and thank you. You are welcome. Any additional comments? If I'm incorrect, if it's a civil matter, an application for maintenance order, or subpoenaing the party, or calling the party to court for an application for reduction or an increase, let us know and we will deal with that. Yeah, question number 1 had an additional comment. Let me copy that in quickly. Let us get that into the system. Question number 1, that's him. Or her. I went to court and they said I must return on my court date on 22nd of March. So I suspect he will finish the money. He only has 2 years of service in the company. So I would advise you under those circumstances that you need to maybe approach a maintenance court and tell them your dilemma. It does not mean he will not pay maintenance afterwards. If there is that apprehension and you presume he will not be paying maintenance, then obviously you need to act upon it. I do not know the amount of money you're talking to. He only worked here for 2 years, so I presume that the maintenance amount won't be, the retrenchment amount won't be that huge. Also depends upon how much the person is earning. So it's a difficult situation to deal with because you are making the claim, the allegation that you know he will not pay maintenance and therefore need to attach this retrenchment amount because you are afraid that he will not pay the maintenance afterwards. But you have not determined whether or not there is a justified claim in the amount. And we haven't determined based upon whether or not what your portion of maintenance should be and what the other person's portion of maintenance should be. Sometimes it's a bit hard to give these webinars because you're talking to a screen, you're not seeing anyone. I think we're going to upgrade these webinars where we are allowing people to join us via voice as well, and we can incorporate that into our video. So you can call in via WhatsApp, we will get the sound into the system, and everybody would be able to hear that. And maybe going one step further, we can have those people who want to engage with us via video, we can stream them in via Zoom as well, and we can put them onto the screen. But for that, I might require some additional assistance. I hope it answers question number 1's answer. You need to get the maintenance matter done as soon as possible, and alternatively, or what you could possibly do now is go to the maintenance court and mention to them your concerns. Here's another question, question number 4. We copy it in. Therefore, if question number 1, 2, or 3 has any additional comments, you're welcome to pose it. Just mention question number 1, 2, or 3. Question number 4, the comment is the following. If I have lost contact with the father of my child and we have had a maintenance order in place, he has not paid maintenance in 3 years, and I have not gone back to court to report lack of payment. What are my next steps in terms of getting him to start paying, and what happens to the arrear amount? It's a bit of an easy question to answer, and thank you for the question. The arrear amount continues despite the court order. The court made an order, a maintenance order. It's a valid order. Done. Therefore, he has to comply with the order and is committing a criminal offence by not complying with the order. So the arrears stands. So the arrears, I'm using a silly figure here, 1,000 per month. He didn't pay for three years. That will be how much? It will be 36,000 rand. He owes you that amount of money. What can you do? I would advise you, number one, to go to the maintenance court as soon as possible. There's no time lapse for that. And lay a complaint against him. More than likely, they'll follow the criminal route and they will subpoena him to the criminal court, and more than likely, he will start paying or come to some type of an agreement, some type of an arrangement. The civil route would obviously be that they can start attaching his property, but I would actually advise you, start the process. He owes you the money and he has to pay it. First step, go to the maintenance court and they should be able to assist you. Now, they will assist you. The very bare minimum they should do is find out where this person is, subpoena him to court, and start the process. I hope that answers your question. You can still do something. And my advice to you is, whatever proof you have that it has not paid, so if he had to pay into your bank account, you need to come with statements to show that the court order says he had to pay into the specific bank account. Here are the details of the bank account. Here are the statements for the last 3 years. I presume you have that specific proof. If you do not have that proof and we can't get it, he can make that allegation. But I have been paying her, and he'll know that you only have evidence for the last 12 months and you have nothing else to prove. The court will obviously believe him because you, those who allege, must prove. And that's my advice to you. Make sure that you can prove to the court that he has not been paying. I hope it answers question number 4's question or comment. If there are any additional comments or questions, feel free to pose it and I'll try my best to answer it. Please remember, if you're watching this video, the Advocate Mohammed Abduroaf Facebook page. Just above there, it says post questions on Advocate Mohammed Abduroaf. Type that into Facebook and you should get a page. And if this, while this video is streaming, this video will appear on that specific page. We're also now allowing or making it possible for you to pose your questions before the time. If you are not available at the next webinar, I unfortunately cannot stipulate what time it will be with this COVID-19 and judges and courts having different ways of operating. You must wait for your phone call. You only find out in the morning whether or not it will be virtually done or via in person, and so on. So it's a bit challenging, but I try to do these webinars at about between 9 and 10 o'clock. And yesterday's webinar was the afternoon because I was in court the entire morning. But however, that's how it goes, and we'll try our best. But if you have a question and you're not available to watch these webinars, or you do not know what time it will be, you're welcome to message us that question on the Advocate Mohammed Abduroaf Facebook page. Message, say, question for the next webinar. You must mention that. Question for the next webinar. Otherwise, I wouldn't know. Is it a question, a general question, or is it a question for the webinar? So mention question for the next webinar. These are the facts. And at the next webinar, I will pre-post it onto the whiteboard so we can start dealing with that immediately. Then when you come back from work or wherever you are, or you have free time, watch the video and I should have dealt with that specific question. I have another comment. Oh, the questioner says, thanks, you are welcome. The last question, question number 4. You're welcome, and I hope that answers your, we did answer your specific question. If there are any additional questions, feel free to pose it. Otherwise, I think that's our webinar for today. 20 minutes of live streaming. If there aren't any, I thank you for your time, for watching this webinar, and I will see you online tomorrow morning again. It will be in the morning, most probably between 9 and 10 sometime. But if you have any questions before the time, please feel free to post it. Have a lovely day, and I'll see you online soon. Thank you very much. Good morning. Welcome to our live webinar streaming on Facebook Live. I hope you all are well. You had a lovely start to the week. It is May. We had a public holiday on a Saturday. Doesn't help many people. Some people are already not working, but those of you who have been working on Saturday, I trust that you were paid double for working on a public holiday. Unfortunately, I think I also worked on Saturday. I thought I got paid double, but that's fine. That's the job of a lawyer, to do his work and make sure his client is happy with the results. Nonetheless, our topic today, care, contact, and guardianship rights. Is there a gender preference? Before I start with that topic, I'll give people a few moments to join us and to have the opportunity to interact if you want to. You may interact via the Advocate Muhammad Abduroaf Facebook page. It's above there. Or you can send us a message later after you watch this video. And tomorrow or Thursday, when I do my next webinar, I will refer to those specific questions and deal with them later. And I shall also leave a comment or a reply to your comment stipulating what time I will be doing my next webinar dealing with your specific question. Nonetheless, we are live now, and let us get the wheels moving. Care, contact, and guardianship rights. Is there a gender preference? What do I mean by that? Does the law prefer having a situation where the mother is the primary caregiver of the minor child as opposed to the father? Is there a stereotype that believes that mothers are better caregivers overall throughout the minor child's life than fathers? Is there a preference that fathers are better caregivers for boys as opposed to girls, and vice versa? That's what we are dealing with today, the preference. The reason why I chose this topic is because many people, especially men, they come to me for assistance with the view that they are only entitled to certain care and contact rights. For example, that they are only entitled to have contact on every second weekend and maybe midweek contact and half school holidays. They come to me with that predisposed view and understanding that the law will never consider the possibility of them being primary caregivers. And that's not how the law works, and I will be doing them a disfavor, and to all my viewers a disfavor if I promote that specific understanding and view. What the law looks at is what is best for the minor children, despite gender. We all know that mothers work just as hard as fathers. They have jobs, full-time jobs. Fathers have full-time jobs. In a domestic relationship or situation, either by marriage or partnership, whatever the case may be, mothers and fathers go to work. The child wakes up. Both parties may, depending upon the facts, assist the minor child in getting dressed, feeding the minor child, whatever needs to be done to get the minor child to start the day. The father might be the one that takes the minor child to school, and the mother may be the one that collects the minor child. Should the minor child fall ill, depending upon how the schedule is the next day, if the father has an easy day the next day, then under those circumstances, the father will take care of the minor child the night before. If the father has a busy day, or he had a busy day and the minor child is ill, then the mother will take care of the minor child, and so on. So there's an equal caring of the minor child. Now, dealing with that specific scenario, should those specific parties separate or divorce, they need to now determine what should happen to the minor child. How should care and contact arrangements be implemented? Is there automatically a default scenario situation that the minor children should now be living with the mother? The father will be moving out. The child should remain with the mother. Or the mother is leaving the matrimonial home or the family home, and the kids must go with the mom, despite it always having been that both parties cared for the minor child during the relationship. Now, unless you want to apply the stereotype or the common example, not the common example, the common view, that if a child falls ill, it's only the mother that can care for the child. If the child requires something, the mother must do everything. The job is for the father to go to work, earn a salary, and the mother stays at home and she looks after the kids, looks after the home, make sure the home is clean, food is cooked, and so on. That could have been the old stereotype, how things used to work in the past. It still applies to some certain households, still. Many households follow that specific scenario. There's nothing wrong with it at all. Where the mother remains at home and she cares for the kids, she irons the father's shirts, makes sure that everything is done. So when the father comes home, he can eat and she will continue looking after the kids. Now, under those circumstances, it would make logical sense for the minor child to remain with the mother should the parties separate. And I will be honest with you, that makes sense. It makes logical sense. It won't make sense for the father under those circumstances, especially if he never really cared for the minor kids. On weekends, he spent time with the minor children. They went out to the beach together as a family, and so on. However, when it comes to the caring of the minor child, when a child requires assistance with homework, who taught the child how to potty, to use a toilet? Who taught the child how to do things that a child requires someone to assist him consistently with? Obviously, the mom, not the dad. The dad was at work. He was earning a living. He was working for the family, and that's admirable. It's good. However, under those circumstances, it makes sense to follow the stereotype in stipulating. Under these circumstances, the minor child would be best cared for if the minor child remains with the mother. However, if the facts are different, if the facts are that the father cared for the minor child just as much as the mother, maybe, but less it's possible, depending upon the circumstances. But now they're separated and a decision has to be made. The question is, how should they continue parenting the minor children post-separation? Should it be 50-50, which I have no problem with if it's workable, where the minor child will remain with one parent for 1 week, or 5 days, or 2 days, or 1 day, depending upon the facts, depending upon the circumstances. If both parents live opposite the minor child's school, so the minor child knows, tonight, I wake up in my mom's home, I'll go to school, and on my way back, I'll be going to dad. Mom knows that the child won't be coming to her, so she can do whatever she needs to do. The next morning, child wakes up, and he goes to school, and he comes back home to mom. That's fine, it works, it's workable. I am not a judge of families. I never was, and I do not intend to be one in stipulating what would be the ideal family situation for you. But if you ask me my professional opinion, my professional answer will be, what is workable? Is 1 day on, 1 day off workable? I can see problems, but if it's workable, it's workable, and that's wonderful. Is a 5 day on, a 5 day off workable? 1 week on, 1 week off workable? 1 week, 2 weeks, 2 weeks, 1 month, 1 month. If it's workable, wonderful, and it will be a happy family. That's very important. I can come with a perfect parenting plan, spend time drafting it, well drafted, good English, good grammar, if this, if that, if this, if that. That applies, well drafted, admirable. However, if it is not workable for this specific family, it's useless. It's a useless piece of paper. It is causing more problems for the family. However, if the parenting plan specifically states that the father can only see the child every second weekend for 1 hour, it's workable. And that's what the people want. The father travels all the time. He lives in Johannesburg. It's a flight down once a month. It's workable and understandable, and that will be the ideal parenting plan. Great. We have some questions on the screen. It's all pre-created, and I typed it out and I pasted it onto the screen for the purposes of getting some context. Let us deal with the first question. I am the mother of my child. Does the father have a right to have primary care over my child? Now, I won't give a yes or no answer, because the person is asking me a subjective question, not a hypothetical question applying to the general laws. Subjective question to her, I would have to ask the mother quite a few questions. Firstly, how was care and contact exercised whilst the parties were separated initially? If they have only now recently separated, I'll ask questions, for example, who cared for the minor child predominantly during your relationship, your marriage, whatever the case may be. I'll ask the specific questions. If the child fell ill, who cared for the minor child? Who done this? Who done that? I need to understand what are the dynamics applicable here. If the father was actively involved in the minor child's life, just as much as the mother, the dynamics are different than a situation where the father worked very hard to feed the family, to care for the family. However, the question is, post the separation, can the father also care for this minor child just as well as the mother can? Things have changed. We have to relook the matter. So my answer to my client, the mother in this circumstances, would be, it depends a lot on the history, on the past, and the capabilities of the parents. A lot of things can also happen. A mother can have a nervous breakdown. She can fall ill chronically, which can affect her capability for caring for the minor children. That could happen in a given scenario. I need to know all these specific information before I can give my opinion. It's only my opinion as to what is practical and workable under the circumstances and whether or not there's a prima facie, a first glance, there's a case. Obviously, if the mother tells me, no, the father is the one that cared for the minor child all the time. I'm the one that worked. I'm a jet setter. I'm a CEO of a company. I never did it into the minor children. He taught him to ride bicycle. He taught him how to fasten their shoelaces. He's the one that potty trained them. He's the one that does all their homework, and so on. They are getting good grades because of him. He's the one that takes them to school and brings them back. He works himself, and he works online, and his clients are in the States, so he works at night, etc. But I'm the mom. I'm the biological mother. I give birth to these kids. Surely the mother will say, should I not have the kids now and the father can have visitation rights? The logic is tainted. Under those circumstances, it will make logical sense and legal sense for the minor children to be placed in the care of the father, and he can continue doing what he does. And the mother can obviously have contact every second weekend, etc. Weekend contact is very important, but during the weekends, there is schoolwork, homework, routine. Unfortunately, the routine will get spoiled a bit because there's not two households. But that's the reality of people breaking up, divorcing, separating, etc. I hope that answers that fictional client's question, and let's get to the next question. Do fathers have a right to have sleepover contact if the child is still young? Very interesting question. One that gets posed to me quite often. And answering it will obviously assist if we apply the question or the comments I made early on regarding question 1. Obviously, if a child gets born, is born, comes out of the mother's tummy, the child is breastfed, it makes logical sense. The child must be with the mom. I support that view fully. I do not think a father can care for a newborn child unless there are other issues, complications, the mother is unable to care for the child, etc. But in normal circumstances, the mother can be the top CEO, the most busiest person on earth, but when she gives birth, she won't be working. She'll be dealing with the child. And it makes logical sense, in my view, for the mother to care for the child, unless there are other circumstances, other facts that will persuade me otherwise. But now the child is older. The child is off the breast. The child is now eating solids. The child can, does not require someone to care for the child the entire night. The child sleeps for 4 hours on one, 6 hours on one, whatever the case may be. I do not want to specifically stipulate an age. Each case is different, each family is different. But the child is self-sufficient to a certain extent. Then the question will be, can the child be in the care of the father? And can the father care for the minor child, despite the minor child being very young, on diapers still? Can the father care for the child during the evenings? Now, how do I deal with such a question? It's a factual thing. Is he capable of doing so? Does he have the insight? Does he have the knowledge on how to care for the minor child? Has he experienced contact during the day? I do not believe in the logic that the father never ever had overnight contact, therefore he should never ever have future overnight contact. We need to start phasing things in. Give the father an opportunity to develop that skill, and that skill will obviously get developed should he spend time with the minor child during the day alone. The child will take a nap during the day. The challenge will obviously be now if the child should overnight by the dad the entire evening. Yes, it's possible that child might be missing the mom and be apprehensive and say, where's my mom? I'm not used to this bedroom. But wean it in. Let the child during the day sleep in that bed or wherever the child will be sleeping in. Keep the child a bit longer there. Maybe later till later the evening, mother can collect the child. So the child can fall asleep at the dad's place, but wake up again and go back to the mom. So you create a phased-in approach, which is very important. So my answer to question 2 is yes, it's possible for a father to have overnight contact if the child is at a young age. It's possible. Depends upon circumstances and other the facts of the matter. If the father is someone that's tired during the evening, has to work early the next morning, and he's making that request based upon wanting to show the mother thing or two, but the child won't be looked after very well, that's a different scenario, because then a very young child might not be the ideal candidate to have overnight contact by the secondary caregiver if the child is too young. If the child is a bit older, I'm going to mention age here, let's say 5 years old, just before going to grade R. Child sleeps right through the evening, child is quite big, mother and the child can have a WhatsApp video or call the evening before the poor child falls asleep, etc. No, that's a different scenario. Then the facts changes a bit. The father can be extremely busy at work, but the child overnight there, they spend some time together, the child falls asleep, has breakfast with the child, tells the child at school, and that's it. So those are the scenarios which you have to look at. My guess will be just as good as your guess, but it all depends upon the facts of the matter. That is question number 2. Question number 3. My son wants to stay with me permanently. I'm the father. The mother does not agree. What can I do? Very important considerations that needs to be applied. Father wants to have primary care over the minor child. The mother does not want that to happen. We have to look at all the factors. Of course, the age of the child, the history, how often the child had contact by the dad, how often has the child had contact for half the school holidays, etc. Are we there? Are we far from that? Do we still need to get there? Do we still need to develop a strategy to get to there? For argument's sake, if the father only had contact with a minor child for 2 days per month, the case becomes a bit more harder. It will be better for the father to try to get more contact first, half the school holidays, and then work towards being the primary caregiver. Not necessarily going to 50-50 first, but 50-50 is actually a situation where both parties are primary caregiver, and I believe if 50-50 works and it has been applied, it's harder to go and make a case for primary care, but it's possible. Nonetheless, we have to look at all the circumstances, all the factors mentioned in question number 1 and question number 2, and the court will have to determine what is in the minor child's best interest. Is it in the minor child's best interest to be with the dad? Can the dad care for the minor child just as well as the mom can, and even better? Will the minor child's education, psychological, emotional needs be looked after when the minor child being cared by the dad better than the minor child needs would have been looked after with the mom, etc.? When I mention the word needs, remember, money has nothing to plays no role in the specific scenario. The father can be extremely wealthy or extremely poor. Doesn't matter. The question is what is best for the minor child. If the father is extremely wealthy and is not in the minor child's best interest to be in his care, then that's it. The father must pay more maintenance to the mom because the mom would require the maintenance if she cannot afford to pay for it. And in the same breath, if the father is extremely poor, but he believes he can care for the minor children better, and he can, actually, factually it's worked out, the mother is extremely busy, working, jet-setting, etc., and then under those circumstances, the mother must pay child support to the dad. Thank you very much for your time, for watching this webinar. No, there were no live questions. I do not see any. But nonetheless, you're welcome to post questions before tomorrow if you're watching this webinar on Tuesday, the 4th of May. If you're watching it on Wednesday, the 5th of May, I might have had another webinar and I shall not deal with these questions again. Have a lovely day and stay safe, and thank you for watching. Good afternoon. Welcome to our webinar. Today's topic, childcare and contact, or sometimes referred to as custody and access. The new term since the Children's Act came into operation, we're using the term care and contact. So that's the way we go about that. Many people still refer or use the term access and custody. And of course, there's the issue of concerning guardianship as well, the legal rights or the legal responsibilities regarding a minor child. Nonetheless, let's deal with today's topic, childcare and contact. Generally, I'll be dealing with the issue concerning various aspects of child custody, child maintenance, guardianship, relocation, and so on. Nonetheless, we have a few questions which people posed previously in the last few days. I have changed the questions a bit to deal with it more in a more legal fashion. Sometimes when people pose these questions, they use shorthand, they type it from their phones, and sometimes you do not know exactly what the gist of the question is. But nonetheless, I tried my best to not to lose too much of what the people have typed when they send these questions to us, and hopefully I'll be able to do justice to the specific question. So I have 5 questions on the whiteboard. This must be number 5 as well. I have 5 questions on the whiteboard and I'll be dealing with those. If you have any live questions, if you are watching this video live, please make use of the Advocate Mohammed Abduroaf Facebook page. I'll be keeping an eye on that specific page, and if you do pose a question on that specific page, I will deal with it. I am seeing a question now live as well, so thank you very much for that. Anyone else have live questions, feel free to pose it. But let me first get through this question list of the people who posed these questions previously. The first question is, the mother is suffering from depression and I think she is bipolar. What can I do if I want to have custody of my child? I see him every weekend and he's 4 years old. Okay, so reading between the lines, it's a father posing this question. He believes the minor child, he believes that the child is not being properly cared for by the mother because of the mother suffering of depression, and he potentially believes the mother is bipolar as well. Now he wants to have custody over the minor child. So the question you'll pose to me, or someone will pose to me, is it by default if a caregiver, a primary caregiver, suffers from depression and is bipolar, does that make that specific parent unable or inadequate of caring for a minor child? And of course the answer is by default not yes. I cannot say yes, it does, because with depression, with bipolar, there is medication for that, and if it's well treated, you should not have a problem. You can continue with life. And also the specific patient or the specific parent may be able to handle the depression and the bipolar very well and care for the minor child in a very good manner. And the flip side, which we're not dealing here with and which needs to be posed, is can the father in the specific example or question, can he care for the minor child just as well or better than the mother can? And the question is, what problems does he have? Does he have any challenges? He might not have bipolar, he might not be suffering from depression, but he might have other conditions or circumstances as well. So by default, you do not deal with a matter like this by stipulating, firstly, okay, the mother has depression, she suffers from bipolar, automatically the child should now go to the other parent, and we presume, without any information before us, that the child would be cared for better by the other parent, or that the other parent can care for the child just as well as the mother can. There are various aspects to look at. Firstly, the age of the child. The specific example, the child is 4 years old, so quite young. And, does depression and does bipolar affect the caring capabilities of a minor child of 4 years old? But I'm looking at that from that specific angle. The other sphere we have to look at is the father. Can he care for the minor child Why is the minor child in the first place not with him? That's very important. And the specific father does not mention that he is capable. He's not providing us with that information to substantiate that he can care for the minor child better than the minor child is being cared for by the mother, despite the depression and despite the bipolar. Or I'm not obtaining information from the father explaining to me the level of the depression. How does it negatively affect the caring of the minor child and the bipolar? Does it affect the minor child, or is the minor child very happy? Because a 4-year-old child is supposed to be happy, enjoying life, going through those milestones, learning how to run, to talk well, to play, to possibly spell the name and so on. So that's what the child of 4 years old has to do, not necessarily having a parent assisting him with assignments, homework, etc., and X, Y, and Z. So nonetheless, if the father in this specific question believes that he can care for the minor child better than the mother because of other reasons as well, for example, he can, stay up at night to care for the minor child should the minor child be ill. His structure, his work program allows him to be a caregiver of a 4-year-old child, and he has the temperament, the patience, and the insight on knowing how to look after a 4-year-old child. Then wonderful, then maybe the playing field becomes equal on that basis, but not by reason of the mother suffering from bipolar or depression. So I hope I answered that specific question as objectively and as properly as possible. Nonetheless, let's deal with question number 2. I have a job offer to work in Dubai. I work as a teacher currently in Gauteng. My child is 10 years old and I want to take her with me. The father's name is on the birth certificate and he does not agree with my daughter going with me. What can I do? He pays maintenance. Okay, a scenario which comes about quite often these days, the issue of relocation. Here we have a primary caregiver, a mother caring for the minor child. The father pays maintenance, and I'm certain he has contact often with a minor child, maybe in terms of a parenting plan or some type of agreement the parties may have. But that's not an issue. Things are going well. Now the mother wants to relocate to a foreign country, and in this case, Dubai, to teach. And she would like to take a child with her of 10 years old. Now, what differentiates international relocation matters with the normal run-of-the-mill care and contact matters are that generally the child in the normal circumstances would be living in the same suburb, the same province, both with the parents. And therefore the only issue is how much contact should the minor child have with the other parent, every second weekend, half school holidays, and so on. Here we're having a scenario where the minor child will relocate with the primary caregiver to a different country, to a foreign country, leaving the parent who remains in South Africa with a total different level of contact with the minor child. He might see the minor child once every 2 years physically. Yes, we know we have Skype, we have Zoom, we have FaceTime, and so on. But however, that aspect of picking the minor child up from school, taking the minor child to school, extramural activities, spending weekends with the minor child, going to the park, going to the pools, going to the beach, and so on, will not happen anymore. So here we're dealing with the issue concerning international relocation, which is quite complicated in the sense of the court must first determine whether or not it would be in the minor child's best interest to relocate with a parent in the first place. So we're not dealing with care and contact issues at that specific time. Then the second leg would be what type of care and contact arrangement should be in place for the specific parents should the minor child relocate with a primary caregiver. But those things are not that hard to work out because, contact would usually be unlimited at reasonable times. And reasonable times can be a bit complicated. Okay, Dubai might not be much of a problem, but let's say the minor child relocates to the United States, whereby a good time for the minor child might be in the afternoon between maybe 5 or 4 and 7 or 8 o'clock. However, that might be a total different time zone in South Africa. And that could cause certain type of complications with the parents having contact. Either the father would have to wake up extremely early, or he'll have to be awake extremely late at night in order for him to have contact. Nonetheless, under these circumstances, seeing that the father is involved in the minor child's life, his name's on the birth certificate, the Department of Home Affairs would obviously require the father's consent for the relocation. They would require that. And at the same time, for the mother to apply for a passport, the Department of Home Affairs would require the father's consent as well. In a matter like this, the mother would have to convince, and the mother is the one asking for the advice, so we are answering this question on behalf of the mother, putting on my advocate's cap for the mother. The mother would have to convince the court that she set up a situation in Dubai that will be conducive for the minor child's well-being. In the sense of she's looking after the minor child while in South Africa during the week, taking him to school, feeding him, caring for him, doing his assisting him with his assignments and so on. But should the minor child relocate with her to Dubai, the minor child would be cared for just as well as he was, or as the minor child has been cared for in South Africa. That's the one aspect we're focusing on, the minor child. You know, the minor child will be looked after. Secondly, the issue of relocation per se. Why does the mother want to relocate? Here is for work purposes. Does it make sense for the mother to relocate to Dubai if she'll be earning the same amount of money? This is in my example, my question I'm asking you. She'll be earning the same amount of money in Dubai as she's earning in South Africa, and there's no logical reason for her to go to Dubai other than maybe experiencing the world. But that is also a valid reason for someone to relocate, you know, to experience the world and to, you know, see different places. So the court would have to look at that as well. Now, after we have concluded that it will be in the minor child's best interest because the minor child will be going with a caregiver, requires to go overseas to better employment or whatever the case may be, the parent remaining in South Africa would have an argument. The parent remaining in South Africa will stipulate, no, the child should not relocate. Firstly, school, change of school, friends, family, you know, contact with the caregiver as well. The father would not have contact with the minor child as often as he has, maybe every second year. And with COVID-19 being so difficult, we do not know what will happen in the future. He might see the minor child, you know, after a very long time again, physically. So he would argue that. And what would his argument be? If he's very good, he would not necessarily argue on the basis that the mother cannot go overseas. He would argue that if the mother wants to go overseas, she can go overseas and she can do what she wants to do. But the minor child should not go with the mother. And with saying that, he would have to argue and present to the court that he can care for the minor child adequately in South Africa and the mother can go away. So that's a debate that has to be determined. And if you look at that specific scenario, that specific situation whereby he caring for the minor child, we have to say, is it best for the minor child to be cared for by the father who has no experience? Let's say those are the facts. He has no experience, the minor child does not know him so well. He usually only sees the minor child once every second week. He remarried, he has some, you know, step kids as well. The house is very small. Whatever the case may be, I understand to be difficult here, making his case a bit hard. But you will have to convince the court, you know, if you consider everything, the child will be living in his environment, but at the same time, the child will be living in South Africa, remaining in his current school, friends, family, and so on. As opposed to going to Dubai, living with a mother, total new school, but the mother as primary caregiver will be looking after him. So those are the debates that will have to take place. So if you are following my argument, you need to convince the court, either father or mother, but here in our case the mother, that it will be best for the minor child, and the minor child cannot remain in South Africa because you are not there, number one, and secondly, the parent living in South Africa cannot care for him or her. So I hope I dealt with that specific question, and if I have not, you're welcome to comment a bit further. The third question, and the person that posed a question on Facebook, I shall deal with the question after question number 5, and then we can unpack it further. What do I do if my child does not want to visit his father? Our divorce agreement says he must visit every second weekend. However, my son does not like his new wife and step brothers and sisters. He's 17 years old. Must I force him? Okay. Divorce parents, divorce order, stipulating that the child should go to the dad every second weekend. So it's an order of court, complicates matters a bit. The child does not want to go because maybe the father remarried and he does not get so well on with the step mother and the step-siblings and so on. But he's 17 years old, he's an adult soon. In the next few months' time, he'll be an adult. Now, when it comes to kids at this specific age, it becomes a bit hard because a 70-year-old is almost an adult. He'll be an adult in a few weeks' time, a few months' time. And what do? Do you force a child who basically knows what he or she wants and who is maybe in matric or grade 11, whatever the case may be, some of them at that specific age is already a technicon. Do you force a child at that age to go to a parent? Yes, in principle, the child does not necessarily decide what's best for him or her. A child decides, the parents decides what is best for the minor child, not the child himself. However, a person has to be very sensitive and smart here. Yes, if you ask me the question, must the child go? If the order said yes, my answer is yes, so you must follow the order. But if you have a situation whereby the child does not want to go, and a parent who would be exercising contact, in this specific case, the father is adamant he wants to have contact to the minor child, and there's a court order in place stipulating that, I strongly believe under those circumstances, you need to take this matter back to the court. The court needs to resolve this issue as soon as possible, because you would not want to force a child of 17 years old to have contact with another parent if the child does not want to, without trying to mitigate the matter. And the way to mitigate the matter would be to take this matter to court, because a child of 17 years old is very vocal, and you do not want to traumatize this child. In taking the matter to court, we of course want a social worker, a psychologist, somebody to be on board to assist in assessing this matter. I mean, remember, the parents, they are not psychologists. They do not necessarily know what is best for the minor child objectively, because they are all acting subjectively. They have issues with the other parent and so on, or sometimes the minor child plays them as well. That happens often. But be that as it may, the mother in this specific scenario needs to take this matter urgently to court and have the court to reassess this matter as soon as possible. But until then, unfortunately, depending on how far she acts, the minor child would have to go to the father unless she goes to court urgently, and the court can relook this matter sooner than later. And because the minor child is 17 years old, there are a lot of variables who play. Number one could be the minor child might turn 18 years old in a month's time. And now you have to go to court, urgent litigation to be heard in a week's time, where that order will only be applicable for the next 3 weeks' time. I think parents will be silly to litigate a matter for 17-year-old on that specific basis, spending so many thousands of rands on legal fees just for the father to have contact with a minor child for the next 3 weeks. And the child will become an adult after that. Okay, so in summary, my answer would be basically focus on what's best for the minor child. However, because there is a court order and the parties cannot come to an agreement, urgently approach the court and have the court reassess the matter and determine what is best for the minor child. That was question number 3. Let's deal with question number 4. I am in the process of getting divorced. I was told that I can ask for maintenance from the divorce court. Is it possible, or must I go to the maintenance court? The answer is yes, it is possible in a pending divorce matter to approach the divorce court itself for a order regarding child maintenance, care and contact. That's possible as well, and also a contribution towards legal cost. So that is possible. So in the High Court, for example, it will be a Rule 43 application. Usually what the parties do is you first issue the divorce summons, you serve it upon the other side, and soon thereafter you make an application in terms of Rule 43, basically stipulating I require maintenance for myself and for the minor children, X amount of money. I would like to have these interim contact arrangements in place. The minor children should remain with me if I'm the mother, and the father can have contact every second weekend, whatever the case may be. And at the same time, we like the father, if he is earning all the money or he has assets and so on, to contribute towards the legal costs. So that's how it works. So it's possible. It can also be done before the divorce and also with the divorce summons being issued as well. So that is possible. Question number 5, the last question before we deal with the live question. The father of my child is missing. He does not pay maintenance nor visit the child. The last time we had contact was in 2000. That's quite some time ago. I think that should be around, it's 2010. My apologies for that. 2000, the child would be an adult by now. I want to get a passport for my child. Home Affairs says I need a court order. How do I get it? Okay, so let's deal with this matter from the foundation. Minor child, the father and the mother are guardians over the minor child. So they both have parental rights over the minor child. I would presume these parties, maybe the child's name is on the birth certificate. I would presume the father is involved in the child, was involved in the child's life at that specific time. But now when the mother went to the Department of Home Affairs and showed him the birth certificate, they said, oh, okay, I see, there is a father, we require his consent. The mother might say the father was not involved in the child's life since 2010. They'll say, how do we know that? You could be lying, whatever the case may be. And they require the father's consent, and they'll tell you, if you cannot get the father's consent, you need to come back to us with a court order. So that's what the mother needs to do. We make those type of applications quite often, whereby parents have challenges in, number one, maybe living or assisting the child in his life, for example, enrolling to schools, extramural activities, consent. For example, let's say the child has to go for an excursion and they require the guardian's consent, or the minor child would like to go overseas on some trip because the child is very talented and the guardian is not available and hard to be found. So nonetheless, under these circumstances, I would advise the specific person to urgently approach the court and ask the court for an order that the court appoint him or her as the sole guardian of the minor child, and in this case, a mother. So basically, you approach the court, you tell the court, these are the problems I have for the last 10 years. Father is missing, he never paid any maintenance. I had problems with enrolling the minor child to primary school, to high school. I'm still having problems. I cannot get a passport for the minor child. All these problems, but the father is nowhere to be found. The High Court will assess this matter, and the court could possibly make an order that, Mom, we believe you, we accept what you are stipulating. Here is an order stipulating that you have sole guardianship rights over the minor child. Go to the Department of Home Affairs, show this order to them, and they would not ask for the father's consent. So that is possible. The court would obviously make an order like that if the court believes it would be in a minor child's best interest, but generally, if the father abandons the minor child and the family and so on, the court would make such an order. Okay, I hope that answers question number 5. If I have not, and you are watching this video, and you have posed a question to us, this usually happens this weekend, you're welcome to comment. We have now the live question. Let us deal with that. Okay, here's a live question. Hi, I'm going to the maintenance court tomorrow. I saw my ex and son at the restaurant and went to say hi to my son. He quickly called his lawyer and said it's harassment. Can he do this? I'm in Johannesburg from Durban and hardly get to see my son, but he says it's his time with the child. All I did was say hello and hug my son, etc. He was excited to see me. I do not necessarily per se, I wasn't there, so I do not know what the other dynamics are, but on the facts mentioned over here, if you were, for whatever reason, coincident at the shopping mall and you see your son, normal people, they greet each other and hug each other. So he would obviously have to prove to the court that it is harassment. What would be harassment would be that you stalked him, you came out of nowhere, you knew you're following him, and that is why you were there and you planned this from the word go to be there and to see your son and to, of course, communicate with the son and limit or in some way or another, not frustrating his contact with his son, but also, you'd prefer you not to have been there. But nonetheless, on the facts which you have mentioned to me, I do not see any form of harassment. If you were there, by the way, and it was a total coincidence, and you in no way frustrated his contact with a minor child. So that should be fine. If I did not deal with the matter properly, please tell me and I will try my best to answer it in a different way. So nonetheless, thank you very much for your time, everybody. That was 5 questions and 1 live question. I think we dealt with it quite well in the last 25 minutes. Thank you very much for watching this video, and I hope to see you online again soon. Thank you for joining us. These type of webinars are very beneficial to people because it gives them the opportunity to pose a direct question to a legal practitioner that specializes in family law. You may come across your specific legal problem for the first time, and do not know how to deal with it, sometimes it's very useful to engage with a legal practitioner who practices or who specializes in the specific field of law, and he or she would be able to fast track your knowledge on this specific topic. Therefore, as I've always welcomed people to pose whatever questions you have. I see we have a live question. Thank you for that. Let me read it out. My daughter's father has opened her an Instagram, Facebook, and TikTok account. She is only 9 and I haven't been consulted about this. Is there anything I can do to protect her from this or do legally? It's a difficult question to deal with. It's not a criminal offense for him to open such an account unless Facebook or Instagram does not allow it, or they might allow it but with parental oversight. And some parents, for a 9-year-old child, they might find it reasonable for him or her to have a Facebook account whereby they will keep a close look out on it. So they will monitor it. Generally, parents would have to discuss these specific things. They cannot, at every point where modern technology comes in, where certain decisions regarding a minor child has to be made, they always at loggerheads. So here it is now the Facebook account, where the parties now have an issue and a problem regarding that. I'm not referring to this specific commenter. A different scenario would be where the child has to get a cell phone. Parents are now at loggerhead. Maybe if they were in the same in one relationship, living together, they would have resolved that specific issue more differently, but they do not, or they cannot. Now, this is a typical issue where the parents have to discuss, they have to work around it, because if Facebook is lawful for a 9-year-old child to have an account with, I do not know, I have not done the research, this is the first time I have had a question like this. And if it is legal and a specific parent wants to have that, that is now obviously that parent's decision. But if you feel that it is harmful and it will cause some type of negative impact on the minor child, and it will actually happen, then the only way I can see this matter can be resolved would be for you to approach the court of law and ask the court to force the parent to stop with the action of creating social media accounts for the specific minor child. You cannot go to the police. What will the police do? It's a Facebook account. What will the charge be? Opening an account for a minor child, unless there are illegal activities taking place on the account. So therefore, please verify firstly whether or not a 9-year-old child can have a Facebook account, or is it the father's account whereby he's posting pictures of the minor child day-to-day activities. But from a point of view, parents should be able to discuss this. As I mentioned early on, tomorrow there will be a different problem, something else, and these specific parents cannot agree upon these things. If the parties were in a relationship, they would have discussed it, they would have just argued it, and they would have made a decision regarding that. So from a legal point of view, I cannot really see any recourse as, for example, going to the police station and so on. The other recourse would be to contact Facebook, to contact TikTok or Instagram and say, this is a 9-year-old child, please close the account. But I'm certain they can open up an account again on a different name and a different username, etc. The only option I could see or presume would be to approach the High Court, and the High Court will have to make a decision if it is in a child's best interest. It can be very expensive. But then tomorrow there's another problem, another issue. Co-parenting counseling, I'll say that's most probably the best thing to do, because when it comes to these type of things, the parents have to agree upon it. And if they cannot come to an agreement, what does it mean? The account shouldn't be opened, or the action should not be taken place, or if they cannot come to an agreement and the party who proposes something, can he go ahead with his or her suggestion, for example, giving the minor child a cell phone or not? That is where counseling and co-parenting comes in. The best of co-parents are the best of parents, and that is best for the minor child. The commenter went further and says to put a stop to it, as she was told by her dad to keep it a secret. It's clearly a family issue. it's not necessarily a legal issue. Tomorrow the child, not the specific commenter, I will never refer to anybody specifically who comments, that will be wrong upon me. But let's say tomorrow we have a scenario where the father lets a minor child wear certain type of clothing. It might be inappropriate for that specific family environment, and tell the minor child, please keep quiet. Do not tell your dad or your mom about this. So whenever the child visits the mom or the dad, the child is allowed to do certain things, or the child is allowed to do swimming or cycling or piano. The parties might be very religious at the father's home, and when the minor child is at the mother's home, they might not be so religious, or they might engage in conduct which is not allowed religiously, but it is allowed legally. From a general point of view. What do you do then? Clearly, parents need to discuss these matters, come to resolution. And my advice, as I mentioned earlier on, are for them to actually go to a professional and to discuss these matters. If they cannot, they need to go to a court of law, and the judge will decide whether or not it was justifiable for the matter to have come before him in the first place. Let us move on. I got an additional question from someone else. The comment of earlier on, you're welcome to add additional comments, and I'll be happy to answer them. The comment is as follows. If there is a garnishing order, how do I get the yearly increase? Unless a garnishing order specifically states that the amount get increased every year, the order. So basically, there will be a maintenance order in place stipulating that the one parent should pay X amount of maintenance per month. If that specific order says there is an annual increase, either in terms of the CPI, the Consumer Price Index, alternatively an amount of 10% or 12 or 15%, whatever the parties have come to an agreement with. If there is such a clause in the maintenance order, and the order becomes enforced in a garnishy way, in the sense of the one parent is not paying the maintenance on time, and now the employer is now ordered to pay the maintenance. If there's an increase in the order, the employer will be forced to pay the annual increase. If there is not, then there needs to be an application will have to be made to the court, and you will have to ask the court for an increased amount, and at the same time try to convince the court that you require CPI to be implemented, because it cannot come to court every year, etc. The challenge I have with CPI and the annual increase of 10%, it might work should the minor child be in primary school. But as a minor child gets older, the expenses changes. He might all of a sudden eat double the amount of money, and therefore the 10% might not have been appropriate. So the ideal would be to approach a maintenance court every year based upon the current circumstances. However, that can be tiresome and obviously expensive. You'll be making use of lawyers and so on, and losing time at work. Therefore, on that note, I would always advise people, the order should specifically stipulate that the one parent should pay for the following expenditure. For argument's sake, either half the school fees or pay for the medical aid, and you work those specific things out. And the cash contribution that actually gets garnished by the employer, that only relates to generally food and maybe clothing. And if you are dealing with the issue concerning school clothing, the order will specifically stipulate that the one parent should pay half the school clothing. So although the school clothing increases every year, maybe by 20% or 30%, that is possible. Or if a minor child this year requires no school clothing, maybe only socks and a trouser, by next year he or she might require a blazer and so on, which will increase the amount greatly. The order will stipulate that he or she should contribute half of that specific expense, which makes life much, much more easier for the parties. Therefore, coming back to the questioner, unless a court ordered a garnishee amount to be increased annually, there's nothing you can do. The same way, even if there was no garnish order in place, someone has a maintenance order in place, it says that one party should pay a maintenance amount of 500 Rand per month. I'm using simple figures. And he or she does not pay, and he or she pays every month 500 Rand per month. Every year. So the years are going on. And the question will be posed, how do I get the CPI an increase? You will have to approach the maintenance court. I speak under correction, but my understanding is that the maintenance courts do not, out of their own stipulate CPI or increased amounts in the order. They expect you to come back to the maintenance court. I might be wrong. I'm certain some maintenance court might have a different approach regarding that. But my understanding is that unless the parties agree on an annual increase, they will only make one amount. And if you require more money following year, you should make an application to court. And the amount the following year will not be based upon CPI or 10%, but the actual needs or the actual reasonable increase that is required. It could be 20% as well. Thank you for that. If you have any additional questions or additional comments, please feel free to pose it. As I mentioned early on, I am watching the Advocate Muhammad Abduroaf Facebook page, Facebook Live. That is where comments should be directed to, and where I will respond from. These specific videos are streaming on other Facebook pages as well, and on other Facebook groups. If you pose a question on those specific groups, I will not see it unless it's on the Advocate Muhammad Abduroaf Facebook page. Then I will definitely see it. Okay, moving on. Child custody and child maintenance, serious topics, serious issues. I have explained quite in depth yesterday how challenging these specific topics are, the challenges that me as a legal practitioner face, and the challenges that you as a parent would obviously face when dealing with these type of matters. But having said that, life is challenging, and important things are usually, worthwhile fighting for. Therefore, if you and the other parent can come to an agreement regarding child custody and child maintenance issues, I strongly advise that you guys seek professional assistance, either going to the mediator, an attorney, someone to assist you in resolving these specific issues. If you cannot resolve these specific issues, unfortunately, you will have to approach a court of law. A question which has come to my table quite often, and which I might have mentioned it previously, is what is the connection between child maintenance and child custody? Or in other words, if I'm paying child maintenance, does it automatically mean that I am entitled to have custodian rights, contact rights, etc. to the minor child? That question gets posed, and obviously that question will have to be properly answered. The quick answer would be no. Those are two separate issues. Child maintenance and child contact rights, guardianship rights are two separate issues. You can have the scenario where a parent pays no child maintenance, nothing, zero, and have contact to the minor child every single day. And also you can have a scenario where one parent cares for the minor child consistently, does not have an income. For argument's sake, the mother, she's at home, she's unemployed, she's caring for the minor child all the time, she has no money to support the minor child. The other parent is paying for all the minor child's needs, but the other parent in this scenario would be the father. He has no rights of contact. He can most probably see the minor child once a year, once a month, once a week, whatever the case may be, although he's funding the minor child's lifestyle, which he should do, because the other parent is unemployed. Because if he does not do that, what happens to the child? How does the child eat? If you have money in your pocket, the other party is not working, how does the child eat, or how does the child survive? We have to look past our egos. We have to be reasonable and focus on what is best for the child. And at the same time, a parent can say, I'll be paying more maintenance. I'm seeing the child for 1 hour a month. What if I give you now double the maintenance? I give you now 10,000 per month. Judge, I would like to have more contact because now I'm paying more. I've got a better job and I can pay more maintenance. Two separate issues. I have another question, or I think it's a further comment from the previous question regarding the garnishee order. It says the following. Will that be an original order? Where clothing is concerned, the order, he was ordered to buy X2 yearly, so it's 2 times a year, and has not increased. How to go about that as well? Yes, the original order will have to deal with the annual increase and the CPI. The garnish order is not a new order. The garnish order is basically a clause. So there is a current order in place for the father or the mother to pay child maintenance. That's the original order. There's an issue in place where the father or the mother does not pay the child maintenance, but there's an employer. So a second order gets drafted, ordering the employer to pay the money over to the mother in our scenario. So it's an order. You can have 4 garnish orders in place. You can have one garnish order against, a garnish order against different employers if the guy or the mother works at different places. But the original order stipulates the amount. So that is the case. So if I look at a scenario, you will have to apply to the maintenance court for an increase. Look at the entire situation. Look at the issue concerning clothing and so on. He has to pay clothing. He has to purchase the clothing if the court order says that. If the court order is a bit vague and it doesn't work so well, then you have to go back to the maintenance court and say, you made an order stipulating that you should pay clothing twice a year. You must purchase a minor children twice a year. You did not stipulate how much clothing and so on. But this is what the child requires. They require a jacket, shoes, whatever the case may be, applicable to your kids. Each family is different. Some families require more, some families require less, some families does not require that specific item at all. And you say, these are the issues which I'm facing. Please, magistrate, please, court, please change the order so the order can be more workable. So the order might have to stipulate either he should give you a sum of money, which can be complicated because every year those amount changes, or this year the child requires a jacket, but jackets cost more money. Like the price of ginger and garlic, all those things have gone up and we didn't expect that. But be that as it may, look at the current situation, look at the problems you have, and make an application to the maintenance court to fix all these specific problems. Anything is possible. The court will have to decide what is best for the minor child. However, the amount and the items the party must pay will be solely based upon the needs of the minor child and what the parties can afford. I hope that answers that. You are welcome to pose additional questions and I will see it and I will try to answer it. An additional question. My ex is applying for shared custody now that I have applied for an increase in maintenance. We have a mediation now at 11 of our finances. He is going to use the pending case at Children's Court to delay the increase. Is this possible? Maybe before I answer that, the ultimate maintenance amount will obviously be based upon the movement and the life of the child. If a reasonable amount of money to be paid for child maintenance is 100 Rand, I'm using silly figures again, is 100 Rand. But that is based upon the fact that the minor child primarily resides with the mother and she buys all the food, she buys all the clothing, she pays for the school fees and so on. That's the amount. Now the matter gets re-looked at, the contact care arrangement gets looked at, and the child will have to spend half the time with the mother and with the father. Meaning that the father who used to spend only 4 days per month. He saw the child every second weekend, 4 or 5 days a month. Now we'll have to see the child or care for the child 15 days per month, 10 days more. The mother, on the other hand, will not have to purchase a lot of food, so much food at least, because the children will be eating at her place 10 days less, and so on. So therefore, the caring arrangements and contact arrangements in relation to the minor child has a direct consequence on the amount of child maintenance one parent should pay towards a minor child. If all else is equal, both the mother and the father earn the same amount of money, basically the same expenditure, and they come to some type of a 50-50 shared contact arrangement, then under those circumstances, it would not make sense for the father to pay the mother any amount of maintenance because they earn the same amount of salary, they have the same expenditure regarding the minor children. Why should he now pay her? He shouldn't. It doesn't make sense. Unless, for example, she has additional personal expenses which are reasonable. Maybe her rental is a bit more, whatever the case may be. But it's a mathematical equation and you'll have to work it out. Going back to the Pacific commenter, yes, that is most probably what I would suggest my client. Before the maintenance matter gets finalized, the court cannot finalize it to finality until the finalization of the current custody matter. The court, parties can agree upon some interim arrangement. Let us say they finalize the maintenance matter, pending the outcome of a custody matter. Well, not pending, there is a pending custody matter. They finalize it today. The maintenance court says, based upon the fact that currently the father sees a minor child for 4 days and the mother cares for the minor child for the rest of those days for the month, the father should pay the mother 100 rand maintenance. 2 days later, the custody court finalizes their matter and they order that the minor child should live in both households equally, shared contact, 50-50. What happens then? Then the father will have to go 3 days later to the maintenance court and have the court order varied. The Pacific commenter mentions that they are busy with mediation regarding the maintenance. She says we have a mediation now at 11 of our finances. It doesn't seem it's a maintenance inquiry or for maintenance trial before maintenance magistrate. Mediation, even if there was no high court matter or 50-50 shared care matter pending before a court, no party is obliged to agree to the request of the other party in mediation. The same way, if the scenario, the father offers to pay a small amount of money, she is not obliged to accept it. And the same way, if the mother wants a high amount of money, the father is not obliged to accept it. Alternatively, even if the mother asks for a reasonable amount of money, the father is not obliged to accept it. He will be silly not to, but he doesn't have to because it's a mediation session. It's an opportunity for both parties to lay the cards on the table and for everyone now to see what's what and what would be a reasonable amount of maintenance pay. If this mediation session does not work, I would say, based upon the mediation session, the party should come to some type of arrangement based upon the current arrangement. The current arrangement is that the father is not exercising 50-50 contact to the minor children, and therefore the maintenance should be reasonable based upon that. The maintenance matter should obviously be postponed until the custody matter is finalized, because then we really know how long or for how many days or where the minor child should or would reside during the Pacific month, so that we can work out the maintenance that should be payable by a party or not be paid. In other words, should there be a maintenance order in place if the parties are sharing contact and care equally, if both parents' income and expenditure are exactly the same? I hope that answers that specific question. I'm being very academic. I'm trying to be general. Obviously, the mediator will do his thing or her thing, and ultimately the maintenance court will have their own opinion based upon all the facts before them. The father will, of course, or his attorney will, of course, argue that the maintenance matter cannot proceed until the custody matter is being finalized. And obviously, you will argue that no, it should proceed to the point whereby there can be a proper interim arrangement based upon today's circumstances, because the custody matter might not be finalized soon. It might take many months for it to be finalized. And because of that, we need to come to a resolution now. And this resolution should at least be in place until the custody matter is finalized. I hope that answers that. I have a new question from a different person. I think this is now the 5th one. What is the consequences of a parenting plan that is not adhered to by the other parent? serious consequences, but it depends. If the parenting plan was only signed by both parents, in other words, it was not made an order of court, it was not registered with the Office of the Family Advocate as provided for in Section 33 of the Children's Act. So there are two types of parenting plans, or finalization of a parenting plan. The one is it gets made an order of court. The other one is where it gets registered at the Office of the Family Advocate. If that is the case, what can I do? You guys drafted the document. Sorry, if the case is that you have not registered it or made it an order of court, it's just a piece of document basically stipulating what the parties have agreed upon, and it's regarding a minor child, so it's not really like a contract for the sense of I owe you money or I will do the following service for you for breach of contract, because minor children issues are looked at as current, as present, how it applies presently, and what is in the minor child's best interest today, not because the parties have agreed to it. If a party has signed a parenting plan and it comes before a court and the court decides no, and I don't think this is in the child's best interest, the court won't endorse it. If the parenting plan was made in order of court, obviously serious consequences can arise because you are in violation of a court order. If a parenting plan was registered with the Office of the Family Advocate and one party is refusing your contact, also serious criminal or serious legal consequences. The commenter of previous is, thank you, you are welcome, regarding the garnish order. The commenter regarding the maintenance matter, the mediation, and so on, made the following additional comment. Trial will commence on the 2nd and 3rd of mediation, if mediation does not work. So I'd imagine 2nd or 3rd of next month, because today is already the 3rd. Then the matter must finalized, and then get a finality on the maintenance matter. And then the child custody matter must still proceed, because that is not dependent upon the maintenance matter, and the maintenance amount is obviously dependent upon the child custody matter. I'll give you a different scenario. Let's say the parties are now in dispute. The minor children are in the care of the mother for that 26 days. They're on the care of the father for the 4 days every second weekend. Now something happened, the mother done something bad or she's unable to care for the kids, or whatever the case may be, the father thinks, now, man, I think the children are old enough and I would like to have primary care over these specific minor children. The father now makes an application to court for him to be the primary caregiver, and the contact arrangements to swap, meaning the mother will see the minor children for a period of 4 days, and the father will see the minor children for a period of 26 days. If that is the case, and that matter is pending, and now the court makes an order and proceeds with this matter to finality, based upon the fact that the minor children are in the mother's primary care, knowing that the High Court matter will be finalized also in a few weeks' time, soon thereafter. The High Court or the Children's Court, dealing with the application for primary care, makes an order stipulating that the minor children should now be removed from the mother's primary care and placed in the father's primary care. What happens then? Here the father has an obligation to pay 100 Rand per month to the mother, but she only cares for the minor children 4 days per month. And based upon the facts, and I'm using silly figures here, the 100 per month is way too much. It's applicable to someone who cares for the minor children for 26 days. And that's that. So therefore, I would say the sooner the maintenance matter can be, the sooner the custody matter can be finalized, the sooner the maintenance matter can be finalized. However, my argument obviously would be if the custody matter is long, it might take another few months, maybe a year, then obviously the maintenance matter needs to be finalized now. And then in a year's time, whatever happens, the parties can come back to court. Thank you for that. I hope I answered your question. If you have any additional comments or questions, please feel free to post it and I'll try my best to answer them. We are now going into half an hour of the formal part of this video. We just passed half an hour. Yeah, but 5 minutes or so we were waiting for people to join. If you have any questions, please make use of the Advocate Mohammed Abduroaf Facebook page. If you would like to receive reminders on Facebook regarding these specific webinars and these videos, you're welcome to do so on the Advocate Mohammed Abduroaf Facebook page. I do not see any other questions, and I hope I have answered those specific questions to the persons who have posed it. I will be online again tomorrow, and this evening at 2 o'clock, I'm with an attorney. We will be discussing family law matters, and you are welcome to join in. It will be very informative and very, very interesting as well. Please share this video if you find it interesting, and I hope to see you at our next webinar. And please follow our page. Have a lovely day. Once again, good morning to everyone to our live Q&A webinar on Facebook Live, where I answer and engage with you in relation to whatever family law related questions you may have. Although the topic is child custody or child maintenance and child custody, you are welcome to pose any questions regarding divorces, guardianship issues, passport applications. I think they fall under guardianship rights, relocation, and so on. Feel free to pose whatever questions you may have regarding that. It will be greatly appreciated, and I'll try to engage best as possible with you. Please note, it needs to be posted on the Advocate Mohammed Abduroaf Facebook page. I'm looking at that specific page. Lastly, many people have requested, and they are still doing so, can they pose a question before the time? And I will post it on our whiteboard the next day, most probably. And later on, when they come from work or when they have time, they can view the video where I have dealt with a question. I have decided I will be doing that from now on, but it needs to be posted on the Advocate Mohammed Abduroaf Facebook page, in the sense of you need to send me a message on that page. Therefore, if you want to have a question answered from me on Facebook Live, for me to post that question on our screen, but for you to view the answer later on, please send me a message on the Advocate Mohammed Abduroaf Facebook page, not my personal Facebook account, however, the Advocate Mohammed Abduroaf Facebook page. Send a message stating there, please answer the specific question, and the next morning when we are preparing the specific stream, we will copy and paste that specific question onto the screen and deal with it. So when you have time and you want to view the video, I will deal with that. I hope that answers that specific query or that specific request. Here we have the first question. Thank you very much for that. Let us copy and paste it onto the whiteboard. Okay, that's question 1. It goes as follows. Where does the NPA fit into an arrears child maintenance claim when it has been converted to a criminal trial? The NPA, I would presume, referring to the National Prosecution Authority. The prosecutors at court, so if you go to court and you're involved in a criminal matter, there will always be a prosecutor trying to find you guilty, basically. He prosecutes the case. They're not persecutors, they're prosecutors, and they have an obligation to make sure that justice prevails. You, on the other hand, will have your defense attorney or your defense advocate defending you. The prosecutor will put a charge sheet before you. The magistrate will obviously be in court to ensure that justice prevails. However, the NPA has the authority to prosecute crimes and offences within South Africa. Therefore, if a person has not complied with a maintenance order, in answering this question, it's possible for that person to be prosecuted because that person has committed a criminal offense. Under those circumstances, the complaint will be laid at the maintenance court. They will open up whatever documentation, whatever files or folders, charge sheets, dockets, and etc., necessary in order for him to proceed with a necessary complaint. And that will be sent to the prosecutor. The prosecutor, the NPA, will have a look at it, and he will decide now whether or not he will proceed with that specific complaint or that specific offense for not complying with the maintenance order. That's it. That's the long and the short of it. And then the prosecutor will either cause you to appear at the criminal court, and when the trial runs, he will prosecute you. He will call the complainant to court. In this case, for example, let's say the mother, she'll come on the witness stand, that he or she will be his first witness, the complainant. The complainant will stipulate in court, I appeared in the maintenance court many years ago. The court granted a maintenance order. Here's a copy of the maintenance order. The maintenance order stipulates specifically that the father should pay maintenance for this amount of money on a certain date. The father has not complied with the maintenance order, which is a criminal offense. We are here today, and the father is in arrears of 10 months of maintenance. That's the long and short of it. You present all the information. If the father has to pay within a bank account, you show your bank statements. It gets presented as exhibits. The magistrate sits in the middle on nobody's side. He or she just wants to get justice to be seen. And once you are done with your specific testimony, the accused or the accused in a specific matter, for our example, the father, he will, either him or his attorney will cross-examine you. They will most probably try to say, no, there was an agreement in place that he will not be paying maintenance, there's an understanding in place, or he has been paying maintenance and he paid it to you in cash, whatever the case may be. And then that will be it, most probably examination in chief and cross-examination where you are concerned, that's all finalized. There may be re-examination by the prosecutor, the NPA, afterwards. And if there are no other witnesses, for example, maybe monies had to be paid into a different account in a different way, you might want to call those specific witnesses, all to prove that the person has not complied with the maintenance order. Once that is done, the state might close their case, and then the defense comes, and then the father will come on in our example, and he will now say, no, I have complied with the maintenance order, here is my evidence, here's my proof. Or we came to an agreement, the mother understood that I could not afford the maintenance in the first place. There was an agreement that I should no longer pay maintenance, whatever the case may be. And whatever he says, but he will have to prove his case, and he will have to prove that he was not in violation of the maintenance order. At the end of the day, the court will make a decision. If he was in violation, they will obviously do the necessary sanctions. There's a few that they can do, but the person could get up to 3 years jail time for not complying with maintenance orders. And that's the long and the short of it, and I hope I have answered your question. That's the role of the NPA, the National Prosecuting Authority, and the prosecutors at the bottom appear in court, act on behalf of the National Prosecuting Authority. So let us move on to our next question. So that was question number 1. I think we have an addition to question number 1, and we have question number 2. Let me first add the addition. And let me type in question number 2's question so we can have a look at it and not forget to deal with it. And a reminder again, if you have any questions and you're watching this video later on either via YouTube or on the channel, but when it replays later, you're welcome to pose any questions to be answered at our next webinar on the Advocate Mohammed Abduroaf Facebook page. You send me a message there on, and the next morning we'll look at it and we'll copy those questions into our whiteboard before the time. Let me just complete with question number 1's question, and it goes further. So if you have been prosecuted, have you then been found guilty already for contravention of Section 31 of the Maintenance Act? Why then do you have another trial? There is only one trial. The person might refer to a different application. Prosecution, you can't be found guilty by prosecution. You can only be found guilty if the magistrate finalizes its trial and the magistrate makes a decision, provide a judgment that you are guilty of non-compliance or Section 31 of the Maintenance Act. That's it, full stop. So there's not 2 trials. They must find you guilty, and the only way they can find you guilty is through a trial. There could be an additional inquiry later on with a criminal court refer this matter back for an inquiry at the maintenance court. That is also possible, but that's something else. I hope that answers that specific question for question number 1. If you want to add anything else, just let me know in your comments that you are question number 1. Okay, question number 1 says, thank you, you are welcome, and you're always welcome to post any additional questions you may have later or tomorrow. Question number 2, let us deal with that. Good morning, I am an unmarried mother to a 7-year-old in grade 1. So she's unmarried and she has a 7-year-old who's in grade 1. The father has seen my son about 5 times, no maintenance. Should I apply for guardianship? And will this be a high court costly matter? Reason being is he is on the birth certificate and I have no communication with the father, and he has said he will sign over the rights as he wants nothing to do with the child. I'm struggling with school documents and no further passports, etc. will continue to become a problem. Okay, I added that last comment. Yes, I would advise you to approach the court, and unfortunately, I believe only the High Court can deal with these type of guardianship issues. I speak under correction, but my understanding is only the High Court can deal with that. You are welcome to, and I advise you to double check with the Children's Court if they have the jurisdiction to take away somebody's guardianship rights or limit their guardianship rights. Nonetheless, an application will have to be made to court whereby you will basically ask the court for you to have sole guardianship rights when it comes to certain type of decisions. One would be, for example, an application of a passport for the minor child to leave the country, maybe go on holiday with you after COVID-19 comes to an end. The others would, for example, be when it comes to educational issues. The schools might say, okay, we see on the birth certificate that the father is a biological father. Where is he? You'll have the problem all the time. Then you'll have to explain, I do not know where the father is, or the father does not want to get involved in the child's life, and so on. Under those circumstances, obviously, you want to avoid having to explain yourself all the time. Then you will show the court order stipulating that you have the sole decision making when it comes to these type of guardianship rights, a minor child's education, enrollment to schools, purchasing of property, and so on. So my advice to you is, approach a court. Because the father is not opposing this application, he is willing to agree to all of this, then the application should be quite straightforward. You'd obviously want to get a very well-drafted court order to avoid problems happening in the future, especially if you decide to go overseas and go on holiday somewhere else and go to the Department of Home Affairs, etc. So my advice to you is approach the court, see a good attorney that knows about these type of matters. Generally, I would make this application in the High Court. I never done in the Magistrates Court before because I do not think the Magistrates Court has jurisdiction with it regarding that. But I do not want to put my head on the block at this moment. You can obviously double check with him or look at the Children's Act. All my applications in this regard I have made to the High Court. Some of them were opposed, some of them were by agreement, and when they were by agreement, it was very easy, simple. Within a few weeks, we obtained the order. Generally, it was for the relocation of the minor child, whereby should the minor child be in a different country, the father's consent would not be required regarding schooling, medical, education, I said that earlier on, whatever is required under the circumstances, or application for renewal of a passport. It should be much more easier should it not be applying to relocation in South Africa. So there it is. My advice to you is make the application to court as soon as possible. The father will not oppose it. And then for the next 13 years of the child's life until he turns 18, you do not have to deal with the father in any aspects regarding guardianship rights. I hope that answered that specific question. And I'll repeat myself one more time. If you have any questions and you're watching this video later on, please feel free to send us a question on the Advocate Muhammad Abduroaf Facebook page. Like the page, and I will deal with that question the next time I go online. And we have another question, question number 3. Let us deal with that. Then we get it onto the whiteboard. And if you are watching this video, you're welcome to say hi. Please say hi and say from where you're watching it from. It's always good to know where your audience is from. Question number 3. Good morning. Do you need the father's permission to take your child overseas or apply for a passport if he isn't listed on the child's birth certificate but has done paternity tests and pays maintenance? Yes, you require his consent if he's a co-holder of guardianship rights over the minor child. If is a co-holder of guardianship right, and generally many fathers are if he was involved in the child's life and what took in the child's life and so on. I would say besides that, the Department of Home Affairs, they will request, because they'll answer the question, where is the father? And you might say, you don't know where the father is, we do not know where the father, we do not know where the father is, or the father is not involved in the child's life, or the father does not want to be involved in the child's life, and so on. Your problem will most probably be the Department of Home Affairs. They will be your challenge. And under those circumstances, I would advise you, or you're required to obtain a court order specifically stipulating that you do not require the other party's permission any longer. The specific parent can, of course, give consent. He can go with you to the Department of Home Affairs when you apply for the passport, when you apply, or give you a letter of consent stipulating he or she is happy with you going overseas. However, to avoid problems happening in the future, especially under these circumstances, I would advise you most probably to approach the court to get an order stipulating that you are the sole guardian over the minor child, or you have sole guardianship rights over certain aspects regarding the minor child. When it comes to passport applications, going overseas, medical consent, and so on. Therefore, despite a father not being on the birth certificate, that does not give a father parental rights and responsibilities. A father can be very much involved in a child's life, extremely involved in a child's life. He could be married with a mother, involved in a child's life from the word go, but for some or other reason, his name is not on the birth certificate. Something could have happened, or the mother fell pregnant, she gave birth to the child, they got married a few months later. For some or other reason, the father's name is not on the birth certificate. It doesn't mean that the father's name is on the birth certificate, the father has rights, or his name is not on the birth certificate, he does not have rights. The birth certificate has nothing to do, or put it this way, the insertion of the father's name on the birth certificate has nothing to do with his parental rights and responsibilities. It's two separate issues. Therefore, to avoid problems happening in the future, I advise you to obtain court orders specifically dealing with guardianship rights in the future. I hope that specifically answers your question, and if you have any additional questions, feel free to pose it. And the question number 2, yes, says, thank you very much. You are welcome, and you're welcome to pose any additional questions should you have. I'm always happy to assist people and guiding them to whatever direction I can. You will notice on my screen, there's been some movement happening over there. So if you see some movement, it means somebody posed a question here on my right-hand side. And I'm keeping a close look on that specific screen. Moving forward. So looking at our webinar so far, we're dealing with a lot of guardianship issues. 2 issues, passport. 2 questions asked about passport, a very important issue. The Constitution of South Africa allows every citizen the right to a passport. It is a constitutional right. Therefore, if someone wants to oppose your application for a passport for a minor child, let's say the father now refuses consent because he says, no, the child is too young, the child does not require a passport, but constitutionally he or she is entitled to, but you as parents are the guardians, therefore your consent is required. Now the father refuses consent for the application for a passport, and you take it to court, the court will say, here's a constitution, the child has a constitutional right to a passport. Why would you want to avoid or limit the child's rights to have a passport? Unless there's some very, very good reason why the child should not have a passport, I do not believe the court will at any point will refuse such an application. One possible good reason could be that the child is extremely young and there's no possibility of the child going overseas in the near future. That could be a possible scenario. Alternatively, the passport has a certain lifespan, let's say 5 years, and the child intends to only go overseas in the next 4 years' time, and it makes more sense to go to apply for a passport in 4 years, so that it can be valid for the next 5 years. I'm just using random numbers here. You can verify with the Department of Home Affairs on those aspects, and you can argue that if the court grants the order now for a passport to be granted, there'll be issues in 4 years' time because now the child will be overseas. Maybe the child will decide to board overseas and other complications will arise. So it makes more sense to apply for their passport in 4 years' time. But those are silly arguments in the sense of I think the court might even override it in any event. If you have a right to a passport, we can't predict what will happen in 4 years' time. I know many people who renewed their passport just before COVID-19, and a year has passed by, they couldn't go overseas. So that's how life is. Any further questions, feel free to pose it. If not, we are now streaming live for the last 19 minutes. So this might be a half an hour webinar if there are not any additional questions. Now, on this topic of consent for a passport, goes with it the consent for relocation. I touched on it a bit early on this webinar. Relocation, and that's something which kept me very busy before the lockdown, where parents have decided to relocate to a different country. The mother might come to my office and say, you know, life is hard and challenging in Cape Town. I have an opportunity to better myself, better my life for my child. I am the primary caregiver of my child. The father is involved in the child's life to a certain extent. However, I'm the one who has to deal with the day-to-day activities of the child. The child is more closely connected to me, and the father most probably only has contact every second weekend, whatever the case may be. But when I go overseas, I'll have a better life, better education for the child, etc. The downside of that would be the other party, the father, will have contact with the child much less, maybe only once a year, or at best twice a year. Once a year when the child comes visit his grandma, his uncle and nieces and uncle and cousins in South Africa, once a year. And the second time might be when the father visits the parties, let's say, example, Canada. That's the situation, but the mother will say, you know, in South Africa, I'm earning, let's say, for example, 100 Rand, but they'll earn 1,000 Rand. I'll earn much, much more. I'll be able to better my life for me and the child, and we will not have to struggle so much here in South Africa. It's a difficult argument. It's a difficult thing to deal with, because on the one hand, the child will not have any contact, regular contact with a parent in South Africa. But can the parent living in South Africa demand and say, no, mom, you need to stay in South Africa because if you do not stay in South Africa, I will not have contact. But then again, the father, again, he can decide to go overseas without even consulting with the mother, even if he has to have contact every second weekend with a child. He can say, no, I'm not going to Canada. I do not have to consider anyone. So it becomes a bit of a difficult situation, where the father might not be able to support the mother as much as he would want to or what she requires. And all these conflicting rights comes in. But it seems to me the mother will be the one that will be losing the most, because now she stays in South Africa, she continues to struggle, dad continues with his good life, and she must now struggle with the minor child. If she could have gone overseas, look after herself, better herself, but then the father will not have contact, but he will continue with his life. We have Zoom, we have Facebook, we have FaceTime, we have WhatsApp video. So those are stuff to consider. It's a difficult decision to make. I do not want to preempt what the outcome of such an application will be going to court, but the court will obviously have to determine what is best for the minor child under the circumstances. Will it be better for the minor child now to remain in South Africa? This parent that now lives in South Africa, in our example, the father, can he care for the child then? Does he have the facilities to care for the child? Maybe he remarried, maybe has his own children as well. So is he demanding and stipulating, no, the child must stay in South Africa with the mother, cared for by the mother, but he's not willing or capable of caring for the child in the first place. So it places a great demand on the mother, and also limiting her liberty and so on. And she has a constitutional right to travel the world and enjoy life. But the problem we have is the father, he will not see the minor child, which is also extremely important, because the child needs to see both parents. So that's the conflict. It's a huge conflict. The court will determine what is best for the child, and if it's best for the child to go with the mother overseas, relocate with her, the court will make the decision. If it's best for the mother to stay in South Africa, stay struggling, and for the father to have his every weekend contact, because he wants to every week in contact, the mother must continue struggling. The court will make that decision. I'm not preempting. I'm just giving you various scenarios and various arguments that might apply. I saw another question came in, and let's deal with that question. I'm highlighting it now. Question number 4. I have so many windows open in front of me. I must find out what window applies. We're on the whiteboard. Good day. Could you please advise if a parent's access has been removed and has not made any effort to go through mediation? How do I go about getting a passport as we have no contact as per the court ruling? If the other party does not have contact with the primary caregiver of the minor child, then you will have to go to court and get the court to give an order in relation to the passport. Basically what the court does is the court looks at the matter, and the court will now decide whether or not it's best for the minor child to obtain a passport. So if one parent does not want to give consent, or the one parent cannot be found, the order will basically stipulate that the applicant, generally the mother, may apply at the Department of Home Affairs for a passport for the minor child. They stipulate the minor child's name and ID number without the consent of the respondent, meaning the father. And that's it. If the Department of Home Affairs see that order, they will just proceed with the application. And when it comes to the father's signature, they will leave it empty, because the court order says only the mother's consent is required. Therefore, if a party has no access to the minor child, if I'm reading the example now correctly, if the party has no access to the minor child, but the court order does not stipulate that one parent has sole guardianship over the minor child, under those circumstances, both parents are co-guardian, and both parents' consent is required. And under those circumstances, if one parent cannot be found, who is a co-guardian, or refuses contact, you approach your court, and the court will decide what's best for the minor child. That was my comment to the comment of question number 4. If you have any additional comments to add to that question number 4, please feel free to do so, and I will try to deal with that. But I see we have question number 5 now. Let me deal with question number 5. Copy it onto the whiteboard. Just a bit of an interlude, as I mentioned earlier on. If you have any questions and you're watching this video later on and you have specific questions, please make use of the Advocate Muhammad Abduroaf Facebook page and pose your question there. Okay, let's deal with question number 5. If we're busy with an arrear maintenance case and the father still isn't keeping up with maintenance payments, even though we have a maintenance order in place, what can happen, or what am I to do? Also, if I want to get a garnishment order, what do I need to apply and how long does it take? I presume the parties are dealing with a arrear maintenance case in the criminal courts, or has an application been filed, or are we before a maintenance officer trying to resolve this matter? If a maintenance order has been made, it's a maintenance order, it's an order of court. Even though it has been made in the maintenance court, or in the high court, in a divorce matter, or in a child custody matter, whatever the case may be, it's an order of court. A high court order has no more power than a magistrate's court order. An order of court is an order of court, and it must be adhered to. If the party is not adhering to the maintenance order, you lay a criminal complaint. You go to the maintenance court and lay a criminal complaint. He has to comply with the maintenance order. If at some point a party cannot comply with the maintenance order, you need to apply to the maintenance court ASAP. If you know your salary will come to an end at the end of this month, you do not wait till the end of this month first and then apply and not pay maintenance and then apply for a reduction in the maintenance. No, you immediately go to the maintenance court and make an application for reduction. So I hope that answers your question. In summary, quickly, my answer would be the maintenance order must be adhered to, and you lay criminal complaint at the maintenance court because he's not complying with the maintenance order. But I do not know what there's a real maintenance case. Is he applying for reduction already, or has there been a complaint? So the court might deal with the matter in a logistical fashion, in the sense that we're dealing here with an arrear case, but what about a criminal case happening as well? So I think you need to basically get a bit of clarity from the maintenance court. Because usually if somebody is in arrears, there's two options. One is either attach his property or lay a criminal complaint. So you'll have to get some verification from the maintenance court what's happening in your specific case. And the second part of the question regarding the garnish order. The moment a person is complying with the maintenance order, you are welcome to and you should apply to the court for a garnish order, whereby the garnish order, where the employer will be garnished or the employee will be ordered to pay the maintenance on behalf of the employee in terms of this garnish order. I cannot say how long it will take with COVID-19 and how long the courts are operating, but it shouldn't be a long process. You proceed to the court, you make the application, 1, 2, 3, because there's no dispute regarding the amount. That's very important to note. So it's not a long procedure whereby you have to show your income and expenditure. All that you have to show is there's a maintenance order in place, the party is not adhering to it, that's it. And the court should grant a maintenance order. There might take some time for them to get the specific order to the employer and for the employer to put it onto their system and make it happen. But that's some logistical issues, but it shouldn't take that long at all. That was question number 5. Thank you very much for that. I hope I answered your question. And the long and the short of it is go to the maintenance court as soon as possible. I have an additional comment on question number 4. I think it's a thank you comment, but it might say something else as well. Let's see. Thank you. You have answered my question. The court has granted no access, but I have not received sole custody. Okay. So she has not received sole custody. When it comes to passport issues, we're basically dealing with the issue concerning guardianship. Custody is a day-to-day care of the minor child, who picks the child up, weekends, and so on. Guardianship are the legal aspects regarding a minor child, like passport applications, relocation, school admissions, medical procedures, contacts with a minor child. Those are guardianship issues. So it's possible for a parent to have no contact rights at all. He's not allowed to see the child, but he has guardianship rights. So when a child wants to go overseas or get a passport, he or she must be consulted or the consent is required. So I hope that answers that specific question. And I see we're running out of time. We now past the 31-minute mark for the live stream. And I think we can cut it short unless I receive any additional comments. So in summary, regarding our format for the webinars going forward, if you are watching this video and you want to pose a question for our next live Facebook webinar, you are welcome to post a question on the Advocate Muhammad Abduroaf Facebook page. Type it in. It's a page. Send me a message, and your question will be posted onto our next webinar. It will be on the whiteboard, and it should be receiving some type of preference. Or what I do is I deal with them one by one, but I will deal with it for sure at the next video. Thank you very much for your time, and I hope you found this video useful. If you have, appreciate. Many people can benefit from this. Otherwise, I'll see you at our next webinar, which will be tomorrow. Have a lovely day. Good afternoon. My name is Muhammad Abduroaf, and those who are joining us via Zoom, thank you for joining us. And whoever comes and join us, I will just add the details. I think we're set. So today's topic is Child Custody Disputes and Battles, Part 2. How do I get the best out of my case? So if you are watching this video via Zoom, it is for half an hour. If you have any specific questions, you're welcome to type it in, and I'll be able to see it. Somebody said hello. Thank you for that. Hello back. If you have any specific questions regarding child custody, please type it in, and I'll be able to see it, and we can deal with that. If you are watching this video via Facebook Live, that's a link on top, facebook.com/ADV Muhammad Abduroaf/live. You are welcome to post any questions. I'll be monitoring that specific platform as well. There aren't any questions yet. So let's move on. Let's deal with this topic. Previously, we dealt with this topic regarding child custody difficulties. And as we go along, we'll try to unpack certain issues. The idea behind these webinars are basically to get you to understand from a layperson's point of view, how to deal with these specific problems. Many people, they look up the law, they look up the Children's Act, the Constitution, etc. And it's quite complicated pieces of documentation. Me, for one, I continuously have to look at the Children's Act, look at various sections, and sometimes I get confused because those specific sections don't make any sense to me. And then you go to court and you argue a matter, and then the judge has a certain interpretation regarding a section of the law. The advocate on the other side, or the attorney on the other side, will also have a certain, interpretation on the law. But at the end of the day, is we like to be pragmatical and, sensible and simplify matters. So how do you start this topic? How do you deal with this issue? And I think the simplest way to deal with this issue is when a couple has problems. You can either be a married couple, husband and wife. You could be a couple that was in a relationship, boyfriend, girlfriend, fiancé, and so on, or somebody that just met somebody and you were in a romantic relationship and a baby came about, and that's where we are. How do you deal with this problem? So the typical case would be a client who would contact us and they'll say, I would like to make a consultation regarding custody rights, guardianship rights, care and contact, as the case may be. So we'll meet with the client. Obviously, the client has no idea as to how the law works, how the courts deal with these type of matters, and how do you unpack and how do you specifically deal with these type of issues? It's the first time that you are dealing with it. You may be a professional person. You may be extremely good at what you do. However, when it comes to these personal issues, you have no idea, and you need somebody to assist and advise you. So the first question I would generally ask a person is, what do you want? And believe me, sometimes it takes me a lot of time, sometimes 5 to 10 or 15 minutes to actually find out what this person wants. Then I have to put words in this person's mouth and ask the person, do you want to have custody? Do you want to have the child to stay in your care for the whole week and for the other party to see the child maybe for an hour or two? Then we're getting someone and say, no, I don't want that. I want this. Okay. So we go in circles. But at the end of the day, now I can unpack it, what this client actually wants. And many times what the client actually wants is just to have peace in his or her life, knowing that as the week can progress, as the days can progress, there won't be any type of issues and, controversy happening. So once a person knows exactly what you want, then you can go forward with a specific matter. If what you want is to make the other person's life miserable, if you want is to make the other person to how can I explain to you, to punish the other party, yes, or teach the other party a lesson for not marrying you or not, staying in this relationship, I cannot assist you, the law can't assist you, no one can assist you regarding that. But if you know what you want, so if you're a father that you come to my office and you'll tell me, I would like to have structured visitation rights to my child. I separated from the mother a few weeks ago. She doesn't want me to see the child. I can only see the child based upon her terms and conditions. While we were married, there was no issues regarding my family. The child used to visit my family every single day. They used to play with him. We used to go out a lot and so on. All of a sudden, now that I am separated from the mother, she's living with her parents again. My family is not good enough. She wants nothing to do with my family, and she believes my family is bad. And therefore, I can only have supervised contact with my child, who I saw for the last 10 years. I can only have supervised contact with my child at her home, at her parents' home, for a period of maybe half an hour every second day. So things become complicated now, because while the parties were together, life was good. Things were fine. The mother would leave the child alone with the father overnight if she had to go away for work, as the case may be. But now that they are separated, problems happens. So these are the complicated matters that we have to deal with. If the parties cannot resolve these issues, they would want to fight and, teach the other party a lesson and make the other party's life miserable, and they're willing to spend a lot of money in doing that. That is fine and well. They're welcome to do that. But at the end of the day, is after that exercise has happened, they will basically entitled to get or would have got it in the first place. So the first question, as I mentioned earlier on, what do you want? If you know what you want, we can take this matter further. So now the parties will come to my office and I'll ask the question, what do you want? And they'll say, I would like to have structured visitation rights to my child, or I would like the other party to have some type of structured visitation rights to the child, or I would like the other party not to have any contact rights or any visitation rights to the child. So that's a basis where you're working from, and life becomes very easy for me. Then I'll ask him the question, how involved was the child in the specific, how involved was the parent in the child's life? That's a very important question, and that plays a big role in taking the matter forward. If the other party was not very much involved in the child's life, then it will affect what type of contact rights he or she will have going forward, obviously. So if someone only saw the child once a month, and now he comes to my office and he was always fine with having to see the child once a month, the question is, can he now come to my office and say, I would like to see my child now every single day? It's possible, don't get me wrong, but if you only saw the child once a month for the last 10 years of the child's life, and that's how the child believes how you are involved in the child's life, and the child continues with his life for the next 29 days, knowing that I'll only see my mom or my dad, a month later. Now you come into my office and I would like to say, I would like to see my child every single day or every second weekend, or I'd like to have midweek contact, as the case may be. We can assist you, but we need to be pragmatical and logical over here. If you want to have contact with a child, it doesn't mean it's there for the taking, for the asking. We need to determine whether or not that is firstly in the child's best interest. Is it workable? If the child lives in Hermanus and you live in Cape Town, and that arrangement for seeing the child once a month was workable because of that, but now you want to change it to every second day, where the child might have to travel now to you in Cape Town, and that will possibly not work. So we need to be logical and we have to be pragmatical. So we need to sit down with a pen and paper. And this is what I advise many people to do. If you're watching this video and you have certain problems, and you and the other party are maybe on talkable terms, as the case may be, sit down with a pen and paper, work out what is a pragmatical and the most logical way of dealing with your child custody problem. If you can get past that hurdle, then your results ultimately will be much more easier to obtain. So let's deal with a scenario regarding with a child living in Cape Town and the other parent living, 2-hour drive away from where the child resides. And now this parent wants to see the child every second day. Pragmatically speaking, it won't work. So how do we resolve that issue? We need to get this client. The client wants to see the child more often. He wants to be more involved in the child's life. He feels that for the last 10 years, he was limited with care and contact. We need to determine what is the other party's view on the matter. So I'll ask him or her, what does the other parent say about this? Have you discussed this with the other parent? If he or she tells me, no, I did not discuss it, then I'll say, that is the next thing you must do. Before you must come to a lawyer, you need to discuss this with the other parent. If you have discussed it with the other parent and you guys cannot come to any type of, solution or agreement where the parent caring for the child believes that nothing will work, you're only entitled to see the child 12 days per year, which is too little, one day per month. If that other parent believes that is best for the child, clearly you had loggerheads. It could possibly be best for the child, but maybe not. Under those specific circumstances, I would advise a client, firstly, please see a third-party mediator. Let's not send legal letters out here. Let's not, be, how can I say, like, litigate happy, be court happy here. I'll give them a number of a social worker or a mediator, as the case may be, and let that mediator or social worker sit down on the table with both you and try to come to some type of a solution. I met with a client yesterday and he asked me the question, we discussed the matter, and then I suggested this mediation process to him. He didn't understand it initially, but now he agreed to it. And I said, the reason why I'm referring to mediation is because you might have something on your mind and she might have something on her mind. But at the end of the day, nobody really listens or hears what the other party has to say. And it becomes a waste of energy because the moment you see each other, the idea is basically to talk and give words over. And the other party's mission is also not to listen to you, and he or she wants to give his words and opinion over, and nothing happens at the end of the day. It's just argumentative. So if you go to a professional, an expert dealing with these type of matters, someone that saw this thing so many times, he or she will be in a very good position to mediate the issue and let the parties come to some type of agreement on the specific topic. If that works, wonderful, you enter into a parenting plan, you come to an agreement, simple, then you go back to the lawyer, you make the agreement and order of court. If it's a parenting plan, also you can make it register with the Office of the Family Advocate and so on. And that will basically resolve that issue. If the parties cannot come to an agreement after they have met with a mediator, or one of the parties refuse to go to a mediator, which often happens, it's not something which I don't hear of. But if one party doesn't want to go to mediator or mediation failed, then unfortunately the lawyers will have to get on board. Then the parties will have to, the party that came to a lawyer will have to work out a parenting plan. A proposal, how does he believe that the matter can be resolved? What would be best for the child? Is best for the child going with total 360, where the child is currently residing with the mother, and now the father believes he must have primary care with the child, where the mother will see the child 1 day per month, for example? Or is a better solution being maybe every weekend for the father to drive all the way down to Hermanus, or the 2-hour drive to see the child? Or is it better for the child to come down to Cape Town, if one parent lives down in Cape Town, and have contact with the child? Is that a workable solution? If the situation is much less complicated, where the parties live 5-minute drive away from each other, and the father only sees the child maybe every second weekend, but he believes now that the child is maybe 13 years old, 14 years old, you need to spend more time with the child. And the mother is not willing to do that, or the other party is not willing to do that, then I would say that is a time whereby you write a letter, you attach a draft parenting plan, unpacking the whole situation as to what you believe is a workable situation in resolving this matter. I got a question over here on the Zoom chat. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child. That's a very difficult question, and I will get back to that after I've explained this issue concerning taking the matter to court. Thank you for that. And if anybody else has any further Zoom questions or Facebook Live questions, you are welcome to post them. Okay, so we're dealing with the situation now. They can't come to an agreement, mediation may be failed, as the case may be. A lawyer drafted a parenting plan, a workable document, and he sent it down to the other party. The other party has an option. He or she can obviously now decide, are they going to be reasonable? And they don't have to be reasonable. I don't force anybody to agree to my parenting plan or to agree to what we have to say. There's always a judge in a court of law that can override my decision or my view. Or the other party's view. That's always the case. So you do not have to agree with what we have to say, but you are welcome to give a counter offer. So if my client feels that he wants to have, see the child maybe now every second weekend, and have maybe midweek contact because of the age of the child, and the child wants it, and he feels that he can, provide a better, more quality to the child's life by seeing the child more often, and which could be the case. And the other party obviously refuses that, and that is stipulated in the draft parenting plan. The other party will not be wise if he or she just dismisses that parenting plan. The other party would be smart to look at the parenting plan drafted by his or her lawyer, and to either come with a counter parenting plan, number one, or come with some amendments stipulating, you want to deal with weekend contact. We did discuss this previously. He did bring it up. But I feel that weekend contact will not work because of X, Y, and Z. Wonderful. That's something we can work toward. We can work with. Now, at least I know what the other party's view is. She believes that midweek contact will not work because of the child's schooling, extramural activities, the age of the child. The child might have other siblings. You might not want to break the siblings apart. So, for example, if there are stepbrothers, stepsisters involved as well, that's something which the other party can mention and something for us to deal with and to consider with before we jump the gun and say you are being unreasonable. And there might be other issues as well that has to be looked at and which the other party will bring to the table. We will obviously from there onwards, try to maybe chat to the other party and say, maybe we can sit down on a roundtable meeting. Let's sit down, let's try to resolve this matter, amicably. Let us hear more what you have to say. And let my client also hear more what you have to say. And you can hear what our client also wants to say, which is very important. You will note that my entire approach from the start of this webinar is not court, let's litigate. That's what we do. That's what we make, how we make our living. But this is a family law matter. And the way to resolve these matters are not necessarily via litigation. You can actually break up a family, and I believe if a child must be exposed to social workers, counselors, courts, court-appointed lawyers, and so on, violation of the court order, then the mother goes to the police station or the father goes to the domestic violence court, I don't think that's the way a normal household should generally be. The parties at one point, they were in love with each other. They were, in the parents of the child, they were proud of having the child and lived together. So when problems arise, does it automatically mean that they should now litigate these matters and third parties should now continuously get involved in the matter? They know the child better than anybody else. And I mentioned in a previous webinar also that why would you want to have a judge or a magistrate that looks at your file for 2 hours or for an hour, or if it's a judge that has a lot of files in front of him and he reads very fast, maybe for 20 minutes. Look at your entire case, listen to arguments by the mother and the father, maybe applies maybe 2-3 hours of his time to it, and make a decision regarding the rest of the child's life and your life. Why leave this whole decision of what should happen to your child and your family in the hands of a third party? That's not necessarily the most wisest thing to do. It's a last resort, yes, of course, because we need some type of, normality in this world. So a judge will, put down his hammer verbally and he will make an order. But why do that? The judge doesn't know you. The judge doesn't know the child. The judge doesn't know anybody. He just sees some paperwork and some words that gets uttered and he makes a decision based upon that. I'm being very simplistic here. But I think you know where I'm going to with this. It's best for you to resolve your issues together with the other party because you know what is best for your child, you know your personal circumstances and so on. So let's move on over here. So if the parties have met, they have a roundtable meeting and they discuss this matter, yes, the father might disagree fully with the mother might disagree fully with the father, but remember, people talk, they chat, things changes, that's where the father starts giving away certain things because he now starts believing that the mother is most probably reasonable at that specific point, and the mother starts giving away certain type of rights she might have because the father comes with the logistical and logical answers. And depending upon how old the child is, we can also get what the child's view is. But let's say that doesn't work as well. And if it does work, wonderful. We enter into a parenting plan, we take it to court and we finalize the matter. But let's say that does not work as well. The mediation didn't work, letters doesn't work, the roundtable didn't work, unfortunately. Then the question is, what is the next step? In my specific view, it would be the next step would unfortunately have to be court. This is now where the parties will have a third party to adjudicate this matter. Now the challenge you have is, if the parties do not want to go for mediation, they don't want to sit together, on the same table and so on, the judge will have to make a decision. But let's go further. Let's try to deal with the topic properly. And the topic for today is, if I may quote it, Child Custody Disputes and Battles, Part 2, How Do I Get the Best Out of My Case? If you are watching this video, please share it on Facebook. It will be greatly appreciated. So how do I get the best out of my case? So we dealt with it so far, getting the best out of a case until the date of the roundtable meeting. That failed. Now you need to make an application to court. And I'll deal today with the scenario of making an application in the High Court as opposed to the Children's Court that we can leave for another day. In your application, you have to be very reasonable. You need to explain to the court in your affidavit, why do you now want to have additional contact? Why do you want to have maybe contact in the first place? Why would you like to have shared custody of a child, as the case may be? You basically stipulating whatever you would have told the court under oath should have been in the, should have met with the judge in court. You're now basically stipulating it in an affidavit, in a piece of document. Now, how do you do that? Are you going to spend the entire, let's say, I like telling clients, you got 40 pages. The first 2 pages deal with who is who in the zoo. And then you got the balance of the documentation to make your case. If you were to spend 20 of that pages bad-mouthing the other party, saying every possible bad thing you know about the other party, if you are going to do that, you have full right to do that, then I'm saying you're wasting your money and wasting your time. You should spend the balance of that documentation, that paperwork. No, explain to the court logically, I would like to have more contact with my child. These are the reasons why I would like to have more contact with my child. Before that, you deal with a bit of background. And so you can logically explain to the court that I'm not being vindictive. I'm not trying to take any of the rights away from any parents, but I've analyzed this matter, and these are the reasons why I believe it is in the child's best interest for me to have contact to the child X, Y, and Z. That needs to be unpacked. The court doesn't want to hear about the problems you had with a mother in the past, if somebody had an affair, if somebody was rude to you, in-laws, and so on. It's interesting to read. I'll be honest with you, I find it very interesting. But at the end of the day, when I go through the documentation of my opposing counsel, my opposing party, and I find out where are we dealing with the crux of this matter. And my life becomes very easy as opposing counsel is because I can basically ignore all that stuff that happened before the marriage, before the breakdown. Unless it's specifically pertinent and relevant. We're dealing with stuff like, example, drug abuse, neglect, and so on. But if it's the normal ranting, talking bad about the other party, I can basically ignore it. It's irrelevant. And if you look at the crux of the other party's 20 pages or 40 pages, only 5 or 6 paragraphs are relevant to the case. What does it leave me with? It gives me the opportunity to deal with their 5-6 paragraphs that they dealt with that's relevant to the case, and it gives me additional, let's say, 19 more pages of explaining to the court why my version of this case is more relevant and why I should be successful in my case, whatever the case may be. So, how to get the best out of my case? Firstly, don't waste your time and energy on ranting, on talking bad about the other party. There are countless amounts of consultation I had in my office, and the clients pay a lot of money for that consultation. And generally, in the first, those specific clients, in the first 2 hours, of the consultations, the client will always try to bring about or badmouth the other party. I don't know if it's the nature of how people are. At the same time, if I get phone calls, people contact me, for some advice or don't know what our service is, etc. We advise them about that, but they can't stop the phone call. They need to continue and speak more badly about the other party. And it exhausts me because I got stuff to do and I know it's going to. So please, if you are dealing with a child custody matter, focus on the facts, focus on what is relevant. I will now deal with a question that we had via the Zoom webinar, and I see there is a question coming in from the Facebook Live. Let me get to that quickly. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child at all. It's a very difficult question because if a party doesn't want to see, if a parent does not want to spend time with the child, how do you force that parent to love that child? I, for one, have not yet seen any court law, or as the case may be, that forces someone to have contact with a child, to spend time with a child and to love the child. And that's something very concerning to me. You can force somebody to pay child maintenance, you can force someone to return the child because you're enforcing your rights to have contact with a child. Or you can make an application to court for you to now obviously enforce your rights. But I never saw an application, or I never done an application whereby we asking the court to force the other parent to love the child and to want to spend time with the child, to have contact with the child. And that's very dangerous because what if the other party now spends time with the child and he neglects the child? Well, the other party wants nothing to do with the child, and now you force the child to have contact with him or her, and he just is rude to the child, he's cold with the child, or she's cold with the child, as the case may be, and you want to avoid that. So unfortunately, you can't do much about that. You need to take it upon yourself. I'm the primary caregiver of the child. The other party does not want to be involved with the child's life. That party has an obligation, of course, to maintain the child, take him on maintenance, take her on maintenance. But forcing that person to love the child, unfortunately, we can't do that. I think the law must develop and deal with those scenarios. Then we got another question, and the person says, apologies for going off the topic. This is on Facebook Live. What constitutes an unfit parent? Example, leaving 2 young children alone at home for 30 minutes to drop off a stranger at 4 a.m. in the morning be seen as unfit, especially if the person is not known to the mother or the children. So for argument's sake, there's a stranger in your home and you leave the house at 4 a.m. to drop the child. It's difficult to say, is that unfit parent, and does that automatically mean that the person must not have must have less parental rights and responsibilities over the child. And at the same time, doesn't mean that the other party should now by default, irrespective of investigating whether or not a parent can look after the child, automatically be the primary caregiver of the child. It's difficult to make that jump. Obviously, it sounds irresponsible. I don't know what the other circumstances are. I cannot say it's an unfit parent. We don't know the circumstances, the reasons for doing that, and were the children being safe, were they being placed in neglect, as the case may be. So, for me, as a legal practitioner, as an advocate, to say yes or no will be irresponsible upon me. But at the same time, I would say a person that could possibly answer such a question would be a social worker. Maybe speak to a social worker, speak to somebody that deals with childcare issues, and they can and give them more information, telling them the children are 5 years old, 2 years old, if that is the case. It's 4 o'clock in the morning, there are strangers around, it's very dangerous, X, Y, and Z, and find out whether or not that person was being reasonable under the circumstances. If the kids are most probably, 17 years old, 16 years old, they're quite old, and the mother had to go quickly out at 4 o'clock in the morning to drop somebody out, and it's a very safe neighborhood. They have WhatsApp, they have phone calls, they have phones, and so on. Obviously, the situation will be different. If it's a newborn child, a very young child, and the mothers leave the child to take the child away, that could be looked at differently. So I would say I cannot give my comment yes or no. It's a bit unfair upon me, but at the same time, the person said thank you for my answer. But at the same time, I would advise speak to a social worker, and maybe they can advise you on that specific issue. So I think we dealt now with both issues, both questions. If there are any other questions, we've got about 10 minutes left for this webinar. I'll be happy to answer it on the Facebook Live or on the Zoom webinar questions. So moving on. So you file your application, you stipulate all that's relevant. So you say, I would like to have contact with a child from Monday to Thursday after school. And in your affidavit, you give you reasons why, logically outlaid, beautifully put out. It will make the other party's life very difficult to argue against it. And if they do it, that's great. You need to give the court all the relevant information for the court to work with it. I always tell my clients, you might come to me with your version. I'll put my best foot forward. I will do as best I can to properly outline, do justice to your case in my documentation. I still need to hear what the other party has to say. And the judge will ultimately make a decision. If you've done that, and that specific documentation goes to court, then you are in the best position to get the best possible results out of your case. It's like this. Courts, and I work with a 40-page rule. That's in my personal practice, whereby my affidavits I draft for my clients are generally maximum between 20 pages and 40 pages of data. I think that's also what judges can most probably quickly scan through and make a decision on for child custody matters specifically. Obviously, depends on the case. And then obviously there'll be some annexures attached to it, like birth certificates, letters from schools, from social workers, and so on. If there's abuse, there'll be some pictures applicable, as the case may be. Obviously, some lawyers will draft long, voluminous documentation, and you don't know what's happening over here. It's the same rhyme. There's no logic. There's no structure behind it. So if domestic violence is an issue, you say there's domestic violence. This is the history of the domestic violence. These are the most recent events on domestic violence. You conclude on it. Next issue, non-compliance with maintenance orders. It's not very important regarding child custody matters, but it's something that could be relevant and pertinent. You deal with it. Court made a maintenance order. He does not pay. Let's move on to the next point, and so on. So that's how you outline your specific information. So if you do that, you're in the best position. If you focus on ranting and bad-mouthing the other party, you won't be in a good position. We have another question. Let me get to that quickly. This is on child maintenance, but I will deal with it because the person asked. The court ruled the other party earns double the salary to only financially contribute 40% of the child's needs. How do I dispute that? If a person earns double your salary, the question is, what is that specific person's expenditure as well? So regarding child maintenance, I know it's off the topic, but I think I will deal with it because the person is in our Zoom webinar and there are no other questions. I might earn 10,000 Rand, the other party might earn 10,000 Rand per month, but I have more expenditure because I must buy, shirts, I must buy work stuff because that's part of my attire for work, I must buy a bib, I go to court, as the case may be. So my money, the money that I've left, the net income is much less. With the other parent, he or she might earn the same amount of money as me, however, has less expenses. He works for a boss, pays for all the expenditure at work, get the clothing allowance, and as the case may be. So his or her net income will obviously be much more to use. So that's what we look at. We don't necessarily look at the gross income. We look at the net income. So it's possible that a party can earn much more than you, but pay the same amount of maintenance as you, or earn the same amount of salary as you earn, but pay less maintenance because of the amount of expenditure that specific person has in order to maintain him or herself. Or, for example, if a parent has a medical condition and needs to spend a lot of money on medication, that specific parent obviously at the same time can say, I earn the same amount of money like the other parent, but I have a lot of expenditure, my medical condition, and so on. Or I have to drive further to work, as the case may be. So it is possible. We had a question also on one of our registrants when they registered for this webinar. I said, yeah, I think that is exactly the same question. So sorry, my apologies for not answering that early on, that specific person. So concluding on this topic, how do I deal with my matter? My advice to anybody is watching this video, be pragmatical, be logical, step back from the situation. Don't deal with these type of matters from an emotive point of view. Yes, of course, it's extremely emotional. I mean, I have people coming to my office crying, on the phone crying, because it's emotional, it's their children. That is a factual thing. But we want to be successful in our case. So in order for us to be successful in our case, we need to be logical and pragmatical. There's no other way. I can't see any other way of doing that. Thank you very much for watching this webinar. There are no questions for the Zoom questions. There are no further Facebook Live questions. And we hope to see you at our next webinar dealing with this topic. It will be Child Custody Disputes and Battles Part 2. How do I get the best? Sorry, it will be Part 3. How do I get the best out of my case? Thank you very much. Welcome to the live Q&A on the Advocate Mohammed Abduroaf Facebook page, a platform where we try to answer and engage with you, but specifically answer questions regarding problems that you may face regarding child custody and child maintenance. We had many webinars in the past dealing with those specific topics. We feel it important to advise people and to inform people of their rights, and at the same time to empower you so that you can handle your specific child custody and child maintenance issues as easily and as stress-free as possible. Okay, the questions are coming in. Thank you for that. Please pose some more questions. And I see we have somebody from Somerset West. Welcome. Today's theme would be something which I've been thinking about for some time, and I do not really have a word to, a word to specifically not describe it, but to put it under. Basically, the phrase is toughen up. And the reason why I'm saying so is that having thought about the amount of people I have been advising for the last few months, only for the last few months, and how they have been responding to the specific problems regarding child custody and child maintenance, it seems to me that they have to toughen up a bit with respect. And this is a prelude to the conversation. I'm not referring to you. The persons that I'm referring to might not be watching this video. They may be somewhere else, but those are my experiences. And having thought about it, I've come to the conclusion that many cases, especially regarding child custody and child maintenance, are not successful for the client, or they do not receive the required desired outcomes, is solely because they are not toughing up. It's a silly phrase I'm using, and that will be the theme for the next few webinars. You need to toughen up. You need to look past the fact that you have been manipulated by the other party, with respect to everyone. I'm not referring to any specific gender here. It could be the male that must toughen up. It could be the female that must toughen up. But you need to toughen up, and you need to take control and ownership over your case. Just some random advice to you. Because if you do not do that, you will have to compare yourself to someone that has toughened up, and who will get a better result? The party that is very anxious about his case, that does not want to proceed in fighting for his or her rights because he or she may believe that he or she may be successful. He or she does not want to proceed with his or her case and fight for his or her rights because they are afraid of the other party. They have been victims of domestic violence, gender-based violence throughout their relationship. Toughen up. It's easy for me to say, I know, but you need to do that. So that's just a buzzword for you to hold at the back of your mind when dealing with your matters. And I'll try to think of a theme or maybe have a webinar specifically to deal with that. The same with me as a legal practitioner. I'm luckily for me, I have many years of experience going for 2 decades on child custody and family law and other legal matters. But if my attitude was, when I represent a client and I know there's a more senior advocate or an attorney, or there may be a senior judge who, in front of whom I'm appearing, who is giving me a hard time, I have 2 options. I can either fold. I can tell my client, you know, I'm not put out for this case. I can walk away, let someone else do the case. Or I can toughen up as an advocate, take the punches, give the punches, and give the best I can for my specific client. And that is what you must do. So today's theme, and for the next few webinars, will be toughen up and fight for your rights. We have someone from Cape Town as well. Welcome. Thank you for that. Let's deal with the first question. I was given an order by the court for maintenance. Father didn't appear, an attorney agreed on his behalf. He now refuses to accept and sign the order. What do I do? Now, it's a difficult thing because an order is an order, full stop. At the moment a party, you know, has knowledge of the order, he or she is obliged to adhere to it. The difficult thing what I mean is, it's difficult because the other party is now refusing to accept responsibility in terms of this order, although his or her attorney has agreed to that order on behalf of the client. Then you have to follow the maintenance laws. The maintenance laws specifically stipulate that if a party is not adhering to a maintenance order, it is a criminal offense, and you can have the person, you know, prosecuted for that. And you can go to prison for up to 3 years. Therefore, my advice to the specific commenter is go to the maintenance court, lay a complaint. If the person is working for a boss, you can apply for a garnish order. If the person has certain assets, depending upon the amount, you can have those specific assets attached. So, for example, if the person owes you 100,000 Rand and does not want to pay, it makes more sense to go to the maintenance court and ask for an order to attach his or her car or house, whatever the case may be. I hope that answers that. If you want to add to the comment, feel free to do so. I see the next comment says the following: agree. You have to drive this whole process and be in charge. And I think that goes with the whole issue concerning toughen up. If you do not take ownership of your case, the same way if you're studying for an exam, if you're studying for a degree, a qualification, a diploma, it is up to you to toughen up. You do not understand the work. The work is hard. The lecturer is giving you a hard time. You cannot find the specific relevant material online or in going to the university or to the college, wherever the case may be. You need to toughen up, you know, and start fighting. The same way if you want to lose weight. At the first sign of defeat, what do? You go to the restaurant, you buy food. No, toughen up and lose those pounds. The commenter earlier on added something else. He says the following: easy to say when you are dealing with someone who refuses to abide to the law and the maintenance officers let them get away with their behavior. Been dealing with this issue for 2 years, and now that I thought the matter was over, the father pulls a tactic and now refuses to sign documents. How much tougher do I get? I cannot take it any further. It's very unfortunate where the maintenance courts and the maintenance systems, how can I say, disappoints you. And it shouldn't be the case. I do not know how to respond to that specific question. It's clearly you had a difficult situation where the situation failed you, but I think there are more resources available. It doesn't end there. If he doesn't want to sign, the law doesn't say you must sign. So if an order gets served upon you, you must not, the law doesn't say that the person must sign acceptance therefore. There is no law that says that. The same way, if someone issues a summons against you and you refuse to sign the summons, all that the sheriff will have to do is say, I attempted to serve it upon him, he did not want to receive a service, and I placed it on his door. I put it somewhere so that he can see it. That is it. So the same applies to the maintenance order. You do not have to sign for it. The sheriff will make sure that he gets it. Tell him, sir, you do not want to sign for that, that's fine, but here it is, put it down and walk away. The commenter goes further. And I'm very happy to receive these comments, and feel free to add as much as possible. His attorney is now playing the game and saying that they are waiting on direction from their client. Those are most probably usual attorney tactics, and the attorney knows how to play the game. I would say go to the maintenance court. That makes more sense to me. The maintenance court will have to deal with this matter. Was the maintenance court being conned? Has attorney really had the necessary authority to sign that agreement? Lay a complaint against this attorney if you need to be. If he says, no, I did not have the necessary consent, so you wasted your time, the maintenance court's time, the child's time, and lay a complaint at the Legal Practice Council. The old term was a law society. Do that, but go to the maintenance court and try to resolve this matter. And I think the laws, yes. I'm just finding out where are the comments coming from, connecting it to the relevant client. Okay, I have a new comment over here. My son's father was ordered by court to pay maintenance arrears, which he only paid 3,000 Rand, worth 600 Rand outstanding. Just after he got paid, he was dismissed from work due to drugs. He was told to come back when he is drug-free. What will the court do? If somebody is unemployed and the person owes you money, arrear maintenance money, that arrear maintenance money stays, it remains. It doesn't go away. Obviously, I would advise you to go to the court and explain the situation to them. If the person has assets, those specific assets must be sold, but it seems to me that specific person does not have any of those specific assets. So the real amount remains. And if the person is not paying any maintenance, despite him being unemployed, and he never made an application to the maintenance court to have the maintenance order varied or set aside, the maintenance, the arrears are just escalating and climbing. There seems to be nothing much you can do at this present moment because he has been dismissed based upon drug use, and he can only come back to work once he is drug-free, and that is most probably when he will start earning an income again. So where the father is concerned, it seems to me that's a bit of a waste of energy, but he may have parents who can afford to pay the maintenance on his behalf, and you may want to inquire into that as well. So my advice to you is, go to the maintenance court, explain to them the situation. They might be able to assist you in obtaining that specific money. The employer might owe him money. There might be something which you can do with regard to the employer. There might be other assets applicable that you can attach and make use of. But I would say go to the maintenance court and they will be able to assist you and advise you better on the specific issue. Let me connect the commenters. Okay, we have another comment. Father has played his normal game, The father has played his normal game, has now become unemployed in order not to pay his maintenance. So now it is going back to court for review. He has sold all assets to avoid paying maintenance. Do I fight the grandparents now? If the father doesn't have any income and is unable to maintain the minor child, and those are legitimate reasons, then I would say go to the grandparents. That's the long and short of that. I cannot explain it any further because the child needs to eat and the father is not willing to do his part. The maintenance court obviously have to be reasonable. They'll have to determine, is it fair to go to the grandparents at a specific point? But however, if money cannot be taken from the father and the child needs to eat, the child needs clothing, obviously the maintenance court would be the proper forum to approach the grandparents on your behalf. Here we have another question. It goes as follows. I have been fighting my case for 2 years in the criminal court without a lawyer. The other party have a lawyer and abuse the system and delay. But now the NPA is on the case. If he is found guilty, what will the next step be if he doesn't accept the judgment? Can he appeal again and take it to the higher court? So let me explain quickly how does the maintenance criminal court work. There's no criminal maintenance court. It's a normal criminal court. If somebody does not adhere to a maintenance order, he or she is committing a criminal offense, and a criminal complaint can be laid at court with the prosecutor. The prosecutor will look at it and he will decide to prosecute you for non-compliance with the maintenance order. You will not have a lawyer? Of course not, because you will be a witness. He will have a lawyer to defend him. That's how it works. Same way, if you assault somebody at the criminal courts, the prosecutor will prosecute you, the accused person or the perpetrator. The person who is on the witness stand who has been assaulted, he or she will not have a lawyer. His or her lawyer basically will be the prosecutor, if for lack of a better way of stating it, because he will be the prosecutor's witness. Then they go on, but now the NPA is on the case. So it's possible to delay a criminal maintenance matter. Let's say you appear in court the first time, you say, I would like to get a lawyer on board. The lawyer is only available in a month's time. A month come later, you come to court, the lawyer says, hey, I require the following documentation in order for me to know what's happening in this case. Gets postponed for another 2 months, and it can go on and on. Then the matter gets postponed for hearing, for trial. It gets postponed for plea and trial. On that specific date, the lawyer said, I'm not ready, something came about. So it can go on and on. However, at some point, the matter must proceed. The magistrate will get annoyed, exhausted, and at some point, you have to plea, and the matter must run. If the party is found guilty, as the questioner poses, and he does not accept the decision of the magistrate, he can appeal it, obviously, and is allowed to take it to the High Court. If you are unhappy with the decision of a magistrate's court, you have full right to appeal it. You must explain to the higher court, in this case the High Court, that the magistrate's court made an error. The evidence before it did not justify a decision of guilt on your part. So you're welcome to do that. The committee goes further, and I have an increased application in, but it cannot be heard until the criminal matter is finalized. And in the meantime, my expenses increases, but not the contribution from the other party. It's like there isn't much relief in the interim. The person goes further. Before I comment further, this is the last comment. We now go into trial on the 26th of March. I presume that's for the criminal case. The difficulty with maintenance matters and custody matters and any legal matter as such, if the other party does not want to come to the table, he or she can make life very difficult for you. The same way, if someone owes me money, I borrowed somebody 100 Rand, and he does not want to pay it. He does not want to pay it. And I take him to court. He makes life very difficult in order for me to enforce my rights. The same applies for maintenance. If the specific person understands the system and understands that, how can we deal with an application for an increase in maintenance if I'm already in arrears with my previous maintenance order because I now specifically stipulated that I cannot afford it, and that's my defense, that I could not have afforded it in the first place. How can there be a parallel hearing of the matter whereby the maintenance court will have to deal with the application for an increase, but at the same time, there is an application pending in the criminal courts where the father says he cannot afford it. It makes us logical sense for the courts to deal with one matter at a time. Sometimes a party can take advantage of that. Sometimes the court will make a different decision. The court will say, the criminal matter can pend because we're dealing with an old issue, but now circumstances have changed. The father is now saying he can afford the maintenance, but now the issue is concerning affordability based upon what the mother wants. But the criminal inquiry for non-compliance deals with something that happened a year ago. We did not pay for a few months, whatever the case may be. But my understanding is that the maintenance courts do not prosecute. Obviously, I'm speaking under correction here. Not all maintenance courts might follow this, but they do not prosecute you for non-compliance of maintenance if you pay the arrear maintenance immediately. So let's say somebody never paid for a year. They issue summons, you call to the maintenance court, you pay the arrears, they move on with their lives. So in answering this questioner's question, and the trial being the 26th of March, see what happens in the criminal matter. A lot of information can come from the criminal inquiry because he will have to explain now all the circumstances. You will come on the witness stand. You will explain there was a maintenance order put in place. The maintenance order stipulated the following amounts will have to be paid. You would explain that he did not pay those specific amounts and so on, and he's in arrears for so much. He will come on the witness stand in his defense, and he will explain that he could not have afforded, whatever the case may be. Once that matter is finalized, the court might find him guilty, the court might find him innocent, but then the court can properly deal with the application for an increase. The best person to discuss this with would be with the court prosecutor, because they prosecute these type of matters, or the maintenance officer. Each court is different. Each criminal court has a different policy. It could be that a court might have an experience whereby if each time they prosecute these type of maintenance matters and the father starts paying the maintenance or the mother's paying the maintenance immediately after they've issued summons, it works. So that's a policy. So they do not proceed. Alternatively, they could have had a problem in the past where they run these type of matters parallel. It just causes much more problems and much more difficulty. Because now we are dealing with an inquiry in a civil setting, in a maintenance court setting for an increase. But in the criminal court, evidence is being laid and laid out based upon the fact that the father could not have afforded in the first place. So we have this parallel situation which might not be in the best interest of justice. But also, finality of matters are very important. I would say the courts must be very fast and quick in dealing with these type of matters, and the sooner they can resolve it, the sooner the child's best interest can be upheld. Okay, I hope that answers that specific question. And the commenter made one final comment. She says as follows: affordability is not the defense, or rather, lack of funds is not the defense. Funds are plenty. Then it seems to me that he will be found guilty of that specific offense of non-compliance. And if they find him guilty because he could have afforded, then there's no reason why the application for an increase cannot be completed. And having said that, if affordability is not an issue and there is money available, then the maintenance court must start putting on the gloves and start fighting for you, and then they have to attach these specific funds or whatever money is, get a garnish order in place. The person said, thank you, you are welcome. If you have any other questions, and all the commenters that post comments early on, all 17 comments, you are welcome to pose additional questions, and I'll try my best to answer it. If you are joining this video, please feel free to mention where you're from. We are from Cape Town. We have someone else, let me see now, from Somerset West. If you're anywhere out of Cape Town, somewhere north, Joburg, Eastern Cape, and so on, please feel free to leave a comment or say hi. I'll be keeping a close eye on the screen. Sometimes I have to first analyze the wording because people type from their phones, and I do not want to speak gibberish here. I don't blame you for typing from your phones. How else can you do it? And that's why sometimes I take a bit longer to read it out. And also I must strain my eyes to look into the screen. Oh, we have somebody from Roodepoort. Thank you. That's very nice to hear. It's nice to know where people are coming from. Thank you for that. Going back to today's topic and the theme of toughening up. Why do I say so? Why do I say so? Why do I say that you need to toughen up? And I'm not referring to you, please, I'm not referring to you. I'm trying to give a message out to people, and I cannot see it being a negative message. It can only help you in fighting for your rights and for that of your child. People are of the view, when I come with answers, when I come with suggestions, they always come with counter suggestions and counter answers that exhaust me a bit. They'll ask me the question, advocate, the father is not paying child maintenance, what can I do? I say the law expects you to approach a maintenance court. Advocate, if I go to the maintenance court, I know he says he can't afford it. There is it. He's not toughening up. Advocate, when I go to the maintenance court, I know the court will find his favor because the father is charming. They're not working with you. You need to work with the lawyers. You need to work with the system. Advocate, when I tell them you need to approach a maintenance court, advocate, I do not have the time. Advocate, this is a lot of work for me to do. We will have time to complete all this income and expenditure. We will have the time to make photocopies. We will get the money to make the photocopies. Whereby clients obtain this very good advice on how to deal with the matter. So we're stuck there. I cannot deal with the issue concerning how the tactics I can advise her or him on how to win the maintenance court case. What ideas I have, what strategies I have. I cannot deal with that because I'm still dealing with this preliminary issue about going to the maintenance court, because every time I mention we're going to the maintenance court and fight the matter out there and battle it out for the client, with putting on our boxing gloves and our brains and so on, I get an answer that is, becomes a bit challenging, a negative answer. We must have the time for this. I do not know how to use Excel. I do not know how to use a computer. I never went to university to learn how to use a computer. Oh, the maintenance court, I live in Cape Town, but the maintenance court that I must go to is like there. When will I have time? I must take time off work. And then the end of the day is, why did you come to my office? They came to my office for the sole reason thinking I can make one phone call and get the father to pay the child maintenance. You need to be smart. And many times the attitude, or maybe the theme which I have to apply to that specific scenario would be take ownership of your case. That's it, maybe. Okay, a lot of comments are coming in, and I do not want to lose any of them. We have now 26 comments that came in. Let's see what's happening here. Okay, the report, welcome. The other commenter regarding the money being hidden away. I am in Somerset West. Awesome. What if the father is hiding his money in another account? The maintenance court, if you should do a bit of research, because we cannot look at every possible account, and that's a great possibility that he's doing that. It also might not be true. Maybe he's not also doing so. So you need to find specific links to assist you as to how you can potentially verify that he is hiding the money in a different account. And once you have identified that specific account, then you can approach the court for a subpoena to the bank to disclose that specific account. Okay. Or his family's account. So you need to identify that specific account. Once you know it is, you can take it further. I have another comment. It says, where is he hiding it? Transferred to his mother. I think that's an internal conversation, which is fine. You need to be your own investigator and help the court as much as possible. I agree with that comment over there. You need to take ownership of your case. Thank you for that. Thanks, will try my best. You are welcome and do so. Magic only happens if you put the effort into it. Magic doesn't happen on its own. People learn to do wonderful things out there. Lose weight, surf, mountain climbing, abseiling, fly an aeroplane, because they make an effort. It's magic, but they made an effort. Same way with winning your child custody or child maintenance case. You put in the effort, you will win. The question here asks, can they summons her bank account? Yes, they can. You need to know what the bank account is and what the relevance of the matter is, and they can summons it. They can subpoena, put it that way, they can subpoena the bank for the bank statements. Another comment over here, you need to be on the court's case all the time. Yes, you need to hassle them. The more you hassle them, the more the time they get from you, of you, and they will try to expedite your specific case. Okay, comment yes. Thanks for the advice. You are welcome. We have another comment over here from someone else. Good day. Firstly, thank you for all your advice. You are welcome anytime. The short, my ex is taking me to court for the second time for a decrease, still outstanding from the first time. We're due for court on Monday. My question is, can I sue his parents as well? He does not have the respect for the system. After the first time, he's still going on and doing his own thing. Yes, you can subpoena the parents. However, the court must first be, in my view, satisfied that there is no case against the father. If there is no case against the father, the children cost X amount of money, fine. But at the end of the day, the father and the mother together cannot come up with that specific money. Now we need to look at the higher tier, the grandparents. Then you can do so. My advice to you is speak to the maintenance court. Each court might have their own way of dealing with these type of matters on how to claim maintenance from grandparents. Do they do an inquiry the first time, or do they call the grandparents in all of a sudden? You need to determine from them how it works in your specific court. And once you know that, you A4 away. But they'll be able to advise you on that. I hope that answers your specific question, and you're welcome to add additional comments. I have an additional comment. Going to the maintenance court, he made me become a dragon and a bulldog. Wonderful. Many people want to employ a dragon and a bulldog as a lawyer. If you can be your own one, obviously, with a lot of knowledge, I advise you to sharpen the sword. And how do you sharpen a sword? With a lot of knowledge. But you need to put a bit of energy also. So the sword can be super sharp. It won't melt through the meat or the whatever you're doing with a sword. I'm referring to cooking. You need to put a bit of muscle, so that's where the toughening up comes in. So know the law, that's the sharpness of the sword, but put a bit of energy in and toughen up a bit. The commenter earlier on says, thank you, you are welcome. Thank you for partaking in this webinar. And we got about 4 or 5 minutes left. I need to be offline by 11. Today is quite a busy one. We're having one again tomorrow morning. If you're watching this webinar, I'll be posting the time later today still. But tomorrow around this time, I will be online again to answer whatever additional questions you may have. Someone is replying to a previous commenter. That's fine. I'll say what they're saying. The court investigator picked up my ex-secret bank account via his medical aid record. There's always ways and means. I agree with you 100%. You need to act like a investigator. You watch CSI, you watch all those cool movies. There is a bit of logic behind that. Look through things. Use a highlighter. Highlighters are very good. So you highlight things, Pencil marks. Later on, you might, this specific name or this reference number came up before. Let me go back there, and start working things out. Another comment. I have been in court for more than 4 years, and current maintenance. A year ago, an agreement was made in the mediation in criminal court. Since then, no payment was made on the arrears, the current maintenance, or the current maintenance. That's a concern. I went back to court to let them know, and they will summons him back in March. What is expected at the hearing, seeing that I'm asked to be there? I would imagine it's a criminal matter that's being heard now, so they're subpoenaing him, and he needs to explain his specific circumstances. And if it's not the satisfactory circumstances, then of course they will maybe proceed with a criminal case again. So it seems to me the criminal matter was mediated and the charges were withdrawn and the parties came to an agreement. He did not comply with that agreement. The criminal matter will have to proceed again. That's my view. I hope that makes sense. But at the end of the day, after they've consulted with him, they will have to advise you and inform you of what has happened, and also